Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I know many of you will tell me we are late, but we are not late. I am not late. I am 1 minute early. I'm 1 minute early. YouTube, because of daylight savings time, would not allow me to set for 11 o'clock. It stopped at 10:55 Central. It's not my fault. There was nothing I could do. I said 11 on Twitter. I said it's 11 o'clock, but it wouldn't let me schedule 11 o'clock. It said 10:55 Central Time, and it's because of daylight savings. That's the only thing I can figure, and I hate it. And exposing the lies of YouTube has already caused the stream to buffer. Exposing the lies and slander of YouTube. Ruining my good name. Ruining my good name. I'm so mad. I am so pissed off. Where's my phone? Do you not have phones? Where did I leave my phone and my drink? Are you kidding me? Oh, it's right here. It's right here. Don't worry. It's right in front of me. Phone and drink. Don't panic, guys. Guys, I said don't panic. This is not a problem. Oh my gosh. So, you may ask, what are you doing streaming on a Sunday? You're doing screaming on a Sunday. Sundays are peaceful. No screaming. Well. There will be no screaming on this stream at all. Not a single bit of it. There will be none. None. There will only be mild annoyance. No screaming or streaming or whatever. Today, we are going to be reviewing a video from Philosophy Tube. I don't know if you guys are familiar with Philosophy Tube. I am not. I have never seen that I am aware of a Philosophy Tube video. I've never heard of him. Or whatever. He's a pretty good sized channel. Pretty good sized channel. Much bigger than mine. He's got 766,000 subscribers. And he did a video called Amy Coney Barrett Philosophy Tube featuring Legal Eagle. I was tagged on Twitter with this, and someone said, hey, if you hate your life because I hate you, I'm going to tag you in this and make you look at it. And then they did. They tagged me. I looked at it. It was a mistake. Everything about it was dumb. Should not have done it. Should not have looked at it at all. But I did. And so, I watched it. There are problems with it. Now here I am thinking, oh, good. Thank you for sending me this drivel from Legal Eagle. But his part's just tiny. His part's just a little bit. And then I'm watching like 30 minutes of this weird Britbong try and talk about American constitutional law, and not just like upper level constitutional law, right? Not like, well, this is just what X means, free speech, right? Tone guns. Okay, great. He's talking about judicial philosophy. And what I'm assuming he thinks is that it says judicial philosophy, I am philosopher or whatever, therefore I am sufficiently grounded to comment on judicial philosophy. Well, no. That's not how things work. Just because two things happen to have a similar word in them does not mean that they are the same sort of animal to tackle, right? Like a lion and a sea lion are two different monsters. So philosophy and judicial philosophy can be two different monsters, and they are. They are very, very different monsters. And we'll see some of that as we go. And I will try and walk us through what has happened with this and where he gets assumptions wrong. And again, it's the problem. It's the Devin problem. It's the same thing. It's the same thing. It's coming to you with apparent authority. And he does this in multiple places. Comes with apparent authority and with an idea of educating on correctness. And there's a couple specific spots in the video where we'll probably have to have a discussion about this because that is the premise being sold. Now, it's not just an opinion piece. If it's just an opinion piece, it's fine. Everything is fine. You can have opinions that are good. You can have opinions that are bad, that are right, that are wrong. You can have all these things. It's great. Just fine to do it. But when you start selling people on the idea of education, and he says it pointedly, I wouldn't be educating you if. It's like, well, first faulty assumption that you are educating us now. That's a problematic phrase because to do so, you'd have to be providing educational value rather than a specific and biased perspective. He also attempts to set himself up. It's conflicting, but there are times when he attempts to set himself up as a neutral or a less or unbiased observer, but then there are other times when he's clearly biased in favor of a particular set of thinking. And so it's the deception that is part of the problem. And then, of course, there's the final thing that I hate. I hate this about YouTube, and it is the reliance on raw production value to convey authority. And this video is extremely well produced. It is well made in that sense. It looks nice. It is catchy. It is cute. All of the things that are adequate drivers of dubious educational material. All right. Now, to be clear, I'm not educating you on originalism. I'm not educating you on Coney Barrett. His bibliography is much longer than mine because mine doesn't have to have much to it at all to go ahead and disprove or show problems with the things he's saying. I don't have to do it. I'm going to show you his bibliography. He includes it in his YouTube video description, probably because he's an ass. But that's just my opinion. I'm not educating you on whether or not he is, in fact, comprised entirely of 2 fleshy cheeks and 1 chocolate starfish. I don't know if he is. Maybe there's more to him than that. So, that being said, there's one other reason I'm streaming today. And that is because I have court in the morning. Now, many of you may realize that sounds dumb. Like, wait, if you have court in the morning, why would you stream at night? Well, here's what I would normally do on a Sunday night. I'd go to sleep. Like, I'd read for a while, play video game or something, and then I'd go to sleep. Somewhere around my normal time of going to sleep, 5 in the morning. Well. As it turns out, if you go to sleep at 5 in the morning, it is hard to, there's a window of time where it's hard to wake up, and 8:45 in the morning court is right in that window for me. So, I either had the choice of go to bed at like 10 and still risk having morning wake up issues, because part of my narcoleptic experience is that mornings are awful no matter when they start. All right. So that was one issue, or one option. The other option is to just go to bed after the hearing. Since the hearing is from my home on a Zoom call, I can just go ahead, do this, do whatever, but I'll be awake until, after my hearing at 8:45, and then I'll go to bed after that. So easy answer for me. I'll do a stream. This is presented to me, and I won't have an opportunity in the next couple days to do it. So, I am not a pro se litigant for my own drunken disorderly conduct. No. So, anyway, the long and short is I'm going to be up anyway, so we're doing a stream. I hoped that many of you would join me. Many of you have joined me. All right. By the way, as a PSA, and I'll have to start doing this again, please go and make sure you are still subscribed to Recato Law. If you like the show. If you hate the show, don't do that. If you like the show, go make sure you're still subscribed to Recato Law. YouTube is doing the fun thing where every single live stream I post the notification, and today I lost 34 subscribers by posting a notification to doing this. So YouTube has been punishing the live content. If you like it, please make sure you stay subscribed. They have a habit of unsubscribing people even if you watch every night. So go check it. That's just how it goes. It's a fun thing to deal with, and unfortunately, I will be talking about it, every now and then. It's just so. As a reminder. Also, like the stream or whatever. Okay. So what are we looking at? Here we go. And we'll do super chats that have come in already before the normal super chat routine before we get started on the video. But this is the video you can see down here. Amy Coney Barrett, Philosophy Tube, featuring Legal Eagle, otherwise known as Devin. So here's his description. I'm showing you this first. Let's see. Here are videos you could watch from him or whatever. Who cares? Twitter, all of that crap. Here's his bibliography. Now, here's his bibliography on this stuff. Matthew Adler, Interpretive Contestation and Legal Correctness in William and Mary Law Review. The Role of Experts in Scientific Controversy. He's got writings from Amy Coney Barrett, Countering the Majoritarian Difficulty, Originalism and Stare Decisis, Congressional Originalism, Stare Decisis and Due Process, Precedent and Jurisprudential Disagreement. He's got Mitchell Berman, Originalism is Bunk. He's got The Inside Story of How John Roberts Negotiated to Save Obamacare. He's got a bunch of stuff. Most of this stuff, Franz Kafka in the Penal Colony, Franz Kafka, The New Advocate, Franz Kafka, The Trial. He's got a bunch of stuff in here that is unrelated to this video, or doesn't need to be related. I don't know how he used it. It doesn't really matter. He has fluffed out a bibliography, and I'm not sure how much of it he used. Most of it's unnecessary to this discussion and doesn't appear to be in this discussion. It's not like he cites it in the video in any way. So there you go. But I want to point out that this is what I will say the beginning of what I am terming the deception. The very idea that this much research went into this video. It may have occurred. Don't get me wrong. I'm not slandering the man, saying that he didn't do this research. I'm saying that this research is unnecessary in the context of the video we're watching. And when you watch it, you will notice that it doesn't appear to be borne out in any way. Like, well, I read a bunch of stuff before this video too. Like, do I cite a bunch of Warhammer books because I read them prior to doing this video if I'm not actually referencing them directly? And if I am referencing them directly, where's the citation in the video? Where am I going to say that I got this from? He's written out a bibliography that is very robust, but at what points he uses the bibliography aren't possible to discern. So he's established that he's well read on the subject, but he won't demonstrate that reading. It's just, at the end of the day, either an opinion piece or a very bad education piece. So we'll deal with that too. This is to go towards the appearance of authority. And I'm going to make up some fallacies in this, because if he can make up legal stuff, I can make up philosophical stuff. Fun times. All around. I'm not a philosophy. I don't want to be a philosopher. And though the legal realm and the philosophical realm are adjacent to each other, they have some relation, they share things like logic, philosophy and legal studies are different things. No. Stooge, yeah, we'll probably do a watch party tonight of Blue Thunder. Okay. Let's do these super chats, then I will put on the headphones and we will get this thing started. And you may want to take the next few moments to pray for all of our souls, as this will be a little bit challenging. I should put a trigger warning on it. Bad Vibe says, before you get too far, in the first 6 minutes, the philosopher claims haggis is banned. That is a half-truth. Haggis with sheep lung is banned from being sold as a consumer good, but you can buy Lemoyne haggis or make your own. Okay, thank you. Thank you. Vine the Cold One says, hey, Nick, it means a great deal when you do a show, especially on a weekday. I don't have much to do being disabled, so it's great you are up when I tend to be up. Keeps my mind off of things and gives me a chance to talk. Hey, Vine, I am happy to do so. And if I could promise to do a show every day of the week, I would, but unfortunately, I'm not there yet. Synag8 says, hey, can you do a small favor for me? Can you invite Matt Christensen on for the election stream? He's constantly bitching about needing a lawyer's opinion on some things, but he's too beta to ask to come on your streams. Wait a minute. Matt Christensen, like the giant streamer, the Beauty and the Beta guy, Matt Christensen? Is that who you're talking about? Why would he ask to come on my show? I'd go on his show. Bad Vibes says, I just got a message from Trump. He says, Mr. Ricada has the best rants, the greatest rants. He's one of the greatest ranters on YouTube you'll ever meet. Okay. I'm glad that Trump is plugging the show. Very helpful. Very helpful. AGK says, oh, thank God I made it just in time. Well, there you go. There you go. I'm glad you did. I'm glad you did. Let's get this. Someone asked him to go on my show today. He doesn't know who you are, but he's willing. Lamau. I actually know someone who knows him. Kind of. And I think could get in contact with him. Maybe I'll get him to put in a good word or something. Okay. I can't drink too heavily tonight. 10 minutes from now, my shirt's off. Woo! No, I'm just kidding. Just kidding. All right. Let me make sure you're unmuted. Okay. Let's see. Let's do this. Okay, here we go. I don't know what else to do. I'm delaying because I hate this video. I hate it. I didn't like watching it. Oh, yes, I'll do this super chat real quick. Hayami says, Nick, Sir Sean Connery just passed away yesterday at the age of 90. God bless the man. Yes. Yes. Much honor and praise to Sean Connery, a true man's man and a fantastic actor and entertainer all around. So, good luck in Scottish heaven, Connery. All right. Here we go. No, we covered this. This was not my idea, Jason Poofus. This wasn't my idea. Someone tagged me on Twitter and made me do it. Here we go.
Good evening. Welcome to Philosophy Tube. Tonight's performance features a famous judge, the works of Franz Kafka, a deranged horse, and an illegal pudding. But before the show begins, I'd like to say that at no point during tonight's play am I going to criticize Amy Coney Barrett for
Oh wait, he's not finished talking, sorry.
being religious, for being anti-feminist, or even for being conservative.
And he just did. And he just did. That's the first part of it. He has, by pulling out 3 specific things that he will not criticize her for, he's implicating that they merit criticism. Being conservative doesn't merit criticism. It's just a position one takes. Anti-feminist is an assumption. Is an assumption made about someone. She hasn't expressed pro-feminist or anti-feminist views that I have seen, but he has gone ahead and established these things as both applying to Amy Coney Barrett and meriting criticism by suggesting that he will not criticize her for these things. That's like saying, I'm not going to criticize Barack Obama for being a communist or for doing cocaine. What I am going to criticize him for is blah, 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 blah. It's not honest. It's dishonest from the fucking start. Ugh! Okay.
On the contrary, I'm going to try and be as neutral as I possibly can and explore her ideas on their own merits.
You're already not. You have already failed your test by establishing 3 specific areas that merit criticism that you're going to avoid. You have now set aside in the minds of your viewers that these 3 things make her wrong. You've done it already. Yes, this will be an EFAP. I apologize. We're going to... This 30-minute video will take... Because it's like 5 minutes of credits. Will take us a while to get through. Strap in... you know, dildos ready or whatever.
I think she poses interesting questions, not just for Americans, but for everybody. At time of recording, Barrett has just been confirmed as a Supreme Court Justice in the United States of America. But sharp-eared listeners will glean from my accent and general vibe of cultural arrogance that I am British, and America is not Britain. We've come to accept that now.
There are several jokes that are very normie YouTube jokes that are used in this video. Again, it's the same reasons I hate Legal. Parts of them. Okay, we get it. You're British. and he's going to pretend to know nothing about America coming up, which this gag is going to wear off yesterday.
I hope that when it comes to being fair and balanced, that might actually give me an edge.
You're not attempting to be fair and balanced. I want to point this out because, again, this is part of the fallacy that the dishonesty that he's using here. He's not attempting to be fair and balanced, and I'm not relying on the part of the video we've already watched. Maybe he's forgotten at the time that he's recording this or whatever, but about 2/3 of the way through this video, he intentionally goes away from being balanced. He, in fact, takes the opposite road to tell us, and he announces it. So this idea that he's being balanced, he's setting up a false premise for his audience. It's dishonest. Again, dishonesty. Why?
Her appointment is extremely politically charged, but I'm not a Democrat or a Republican. I don't have to respect the Constitution.
Again, sorry. This is the fallacy of Brittonography. It doesn't matter if you're a Democrat or a Republican, because Amy Coney Barrett isn't being criticized on being Democrat or Republican. In fact, I don't know what her voter registration is. I would infer that it's Republican. She's being criticized in your own video for originalism versus, I guess, non-originalism. But really, it's a specific non-originalism, which is the evolving theory or the living constitution theory. That sort of approach, which you're going to pose as the superior approach, despite ignoring all of the failings of it and assuming that originalism is the course of judicial philosophy with flaws, and that there aren't flaws on the other side. This is the dishonesty you're engaged in, but you've set it up. Well, because I'm not Republican or Democrat, that's fine. I don't have to have an opinion. You still are left versus right. You still are originalist versus living constitution theory. You are the idea of set in stone, conservative, so to speak, versus liberal. You are one of these things, or maybe progressive is more important. Clearly, this man is progressive. He will lay out the ideas in this video that a progressive approach to the judicial philosophy is the better one. He does it subtly, he does it overtly as the video goes on. This is a falsity being presented to his audience. Unfortunately, because I have doubts about his ability to properly teach philosophy to people, I doubt they understand that they're being presented with the falsehood up front. Maybe I'm wrong. I don't know his audience. I don't know his videos, and I am making assumptions, pure speculative assumptions based on one out of context thing. What I will not do is be dishonest about it.
I never pledged allegiance to a flag. What are you going to do? I'm not bound by your laws, America.
Actually, you're on YouTube, so you are. And you're protected by them too. That's an interesting problem you have here, Mr. Britt. You are protected and bound by the constitutional limitations of the First Amendment and how they apply to social media. You're bound by, you're at the mercy of Section 230, frankly. You are bound by American laws because you're engaged in an American business broadcasting to Americans, and you have subjected yourself to the jurisdiction of the United States in all of your YouTube-related activities. In fact, if you were to steal a video and post it, you've already submit to the jurisdiction of U.S. courts, specifically the Ninth Circuit, and specifically the court in San Francisco, if I'm not mistaken, in your YouTube terms of service, for purposes of DMCA, as well as for purposes of copyright in general. You are bound by American laws. You're wrong already.
Look, this is haggis. It is completely illegal in the United States because it contains sheep lungs. You can't have any.
That's great. That may be true. I don't know. I didn't research the legality of haggis because I find it to be completely irrelevant. However, if haggis is illegal due to sheep lungs, or whatever, I would wager there's actually a path for a traditional Celtic or perhaps traditional Scottish person to bring a case for equal protection, allowing them to engage in the creation and consumption of haggis, even though it would be against the law, for the purposes of their cultural heritage or their religion. I don't know. I don't know if anybody's tried it. Maybe they have and failed. They should try again. Go ahead, because this guy believes in a progressive view of the Constitution. Even if they tried and failed, it should be able to be changed in a heartbeat. Yeah. But anyway, it doesn't really matter.
Tastes like freedom. I am based and Anglo and haggis pilled, but one thing I'm not is a lawyer, which is why to help me with this episode, I've hired an actual lawyer and an expert.
Before you laugh, don't laugh yet.
In the American Constitution. Please welcome to the stage, Dr. Bucephalus.
I'm going to pause this and I'm going to comment on the production at the moment, because I have a feeling I'm going to get a content ID claim on this because of the music and all of that stuff. So I'm setting up my counterclaim right here, right now, so that when I tell YouTube that I'm counterclaiming this, it's because I'm calling this video shit. I'm calling it trash. I think the jokes are bad. The musical choice is completely off of what I would think would be appropriate for this type of thing. I don't... Look, he's writing his own... He's got his own closed captioning on here for this. I don't think the musical production fits the overall theme or the overall concept of this video. I think the memeing of Trump and Amy Coney Barrett at her confirmation hearing is boring and reductive and just completely useless to the overall production value. And this is all part of the ongoing deception, which is the fallacy of production. Again, I told you, I'm going to make up my own fallacies because he can make up his own judicial reasoning. So the fallacy of production is one that suggests that due to the production value of a particular program, the underlying message is more likely to be correct or reliable. And I think PhilosophyTube relies heavily on this idea if he's in fact fronting actual arguments and propositions rather than just trying to make money. If he's doing this solely for the purpose of fleecing as many ad dollars out of YouTube as possible, then I do nothing but respect him. Not a single thing but respect him. He's doing it very well. This video has already made him quite a bit of money, and it just premiered yesterday. So good job if you're just trying to grab money. If you're trying to actually convey educative value, I don't think you're doing it effectively. I think the musical choice and the memeing choice is wrong. I don't think it's the appropriate format for it. And that will be a continuing criticism as we go.
I'm afraid of the world. I'm afraid I can't help it. I'm afraid I can't. In June of 2015, Anna Chronis of Illinois, USA, went for a pap smear test and was injured during the procedure.
What he's not going to tell you is a critical part of this case. He's going to... How do I word this? He's going to blithely state in just a little bit that because the particular clinic she went to received federal dollars, that the federal government was able to step into the case as an intervenor under the Federal Tort Claims Act. That is only partly true. That is only partly true. What he will ignore is that this is a specific type of clinic who receives a specific type of federal funds for the sole purpose of avoiding malpractice premiums. in that they can deliver much reduced costs of healthcare by not having to insure for malpractice for their doctors. And instead, the United States government, this is an agreement, the United States government will intervene in lawsuits against the company for malpractice for the sole purpose of reducing the cost of healthcare being delivered to the users. He's going to ignore that. He's going to ignore that Chronis derived a specific benefit in reduced cost of care by going to this particular clinic. And if you think she went to this particular clinic because it was the most expensive and she wanted the best care, you're mistaken. She likely went to this clinic because it was a reduced cost clinic.
Afterwards, she tried to call the doctor, couldn't get through. Tried to call the hospital, they wouldn't get back to her. She then filed a written complaint with the hospital in which she requested $332 for expenses incurred as a result of her injury. The complaint was dismissed. She then said...
The complaint was kind of dismissed. It was rejected. When he says filed a complaint to the hospital in the context of a legal video, it's very important to be clear that he is using the colloquial versions of complaint and dismissed, not the legal versions. She did not file suit against the hospital or the clinic at first, and she did not have her claims dismissed. They were rejected by the clinic. They chose not to honor her claim for $332. They just said, nah. That's it. That's all she did. She said, nah. All right. She then sent a letter to the Center for Medicare. Oh, okay. So she's on Medicare. So her trip to the clinic was likely free, paid for by Medicare. And the $332 she's asking for was not expenses that she incurred for the actual procedure at the clinic, but instead were additional injuries she alleges she suffered. So it's not that she paid $332 and asked for it back to this place. She's saying that she received $332 worth of damages based on the bad care she got. Now, she may have paid $332 out of pocket to some subsequent care. I don't know if that's true. Although, if she has Medicare, I'm not entirely sure why she needed to pay additional funds when her health care would be covered basically for $0 through Medicare. I don't know the circumstances. Maybe she went over the counter. Who knows? Not sure. It's not covered here. But he is, again, leaving out facts. And you can't include every fact. I get it. The video would be 7 hours long like mine's going to be. I get it. You can't include every fact, but these are kind of critical.
Sent a letter to the Center for Medicare and Medicaid Services, a government office, part of the US Department of Health. In it, she said she wanted help receiving the restitution. She also attached over 60 pages of written documents, including the original complaint with the request for $332. Eventually, the CMS got back to her, and they said, "You're in the wrong place, sweetheart. You gotta file a complaint with the Illinois Department of Financial and Professional Regulation."
Does she do it? Does she file a complaint with the Illinois Office of Financial and Professional Regulation?
Over 6 months later, Anna sued the doctor and the hospital in Illinois state court for malpractice.
No, she did not. You notice that doesn't happen. She did not do what they told her to do. She didn't do that. Had she done that, we would have a different conversation happening right now. All right? Stooge Muffin Stuffin' says, if you get a chance, you should watch a movie called Chocolate. I'm Chocolat, I assume. It's about an autistic girl who beats the ever-loving poop out of Yakuza gangsters. It's amazing, and it's on Prime. Oh, is that... Maybe that's not Chocolat. Tet says, PSA, the violence we have seen so far will be a Sunday school class in comparison to the riots if Trump wins. Everyone be safe, stay inside, don't mess with violent people. Crud will hit the fan hard. Be safe. Hashtag go Hots. Go Hawks. There you go. Yes, do be safe. Don't go out like party rioting or whatever on election night either. Okay. We'll get back to this in a second, but for a reminder, the office said you're actually contacting the wrong office. You need to contact this other office. She doesn't do it. Instead, she waits 6 months and then files her malpractice lawsuit, and she files it pro se without representation of an attorney. She's on Medicare. She probably can't afford an attorney. That's for a $332 claim specifically. But hey, here we are.
What she didn't know at the time was that because the hospital technically got some taxpayer money...
Not technically got some taxpayer money. The hospital intentionally receives a good chunk of taxpayer money for the sole purpose of reducing costs to people like her. That's the entire purpose. It's not technically got some taxpayer money. It's actually receives a large amount of taxpayer money as part of its line items, budget line item. It's not like an accidental or, well, a small portion was given here. It's intentional for the purpose of reducing the cost of care, which she enjoyed the benefit of.
The US government would substitute itself for the defendant and bump the case up to federal court.
Yes.
Anna had no lawyer. She was representing herself, but her little homebrew legal case was now Chronis versus United States.
Yep.
Without meaning to, she was suing Uncle Sam. The relevant law in this case was the Federal Tort Claims Act.
This is not the only relevant law in this case. There are other relevant laws in this case, but we'll go on.
Which says that you cannot sue the government until you have exhausted all administrative remedies. So suing has to be your last resort. First, you have to make a claim to the department and then give them time to think about it, maybe offer you a settlement before you jump right into suing them.
Not maybe offer you a settlement. It's not maybe. They will determine if a settlement will be is possible at all, and then they will make that determine. It's not like they maybe offer you a settlement. They will consider the idea of settling the lawsuit in its entirety. It's part of the process. It's a required portion of it.
The government lawyer said that Anna had not done that.
Because she didn't. She did not do that.
She sent the letter with all the attachments, she mentioned restitution, and one of the attachments talked about $332, but apparently that doesn't technically count as making a claim.
And it doesn't. It doesn't count as making a claim. In fact, there's a specific federal form, Form 95, that you use to make a claim to a federal agency for funds. You don't have to use Form 95, but they created the form to make it easy to hit all of the elements of a claim. It would be recommended to look at a Form 95 if you're going to draft a freeform letter and make sure that every element of Form 95 is included in your freeform letter. She didn't do that. And in her claim, she failed to ask, or in her letter, I should say, she failed to ask for $332. Now, do not conflate this. The initial letter she sent to the hospital requested $332. It was attached as an attachment to the letter that she sent in to the federal government. However, she sent 63 pages of attachments to the federal government, to the governmental branch that she was talking to, the Center for Medicaid Services or whatever it was. She sent a letter that does not ask for $332. It actually asks for assistance in dealing with other things. It's almost like I have the quote pulled up here. One moment. I had it pulled up, but Westlaw is annoying and decided to no. Yeah, here we go. Okay, so the letter says, the relevant quote is, Where is it? Here, I'll pull this over so you guys can see where we are. I had it. I, of course, had this thing at the exact right spot, but Westlaw logs you out. It times you out. So it's nice. Let's see. Where was it? Oh, it must be right down here. I'm skimming as we go. Oh, damn it. I'm ruining this entire thing. Wait. Oh, I'm looking at the wrong... This is why. That's the district court case. Hold on. I have the other one pulled up here, too. I was wondering why I couldn't quickly find this. How obnoxious. All right. So if we go here, here's what she said. In her letter, she requested, quote, assistance in resolving a frustrating process of delay, unfulfilled promises, and documented willful ignorance of policy and procedures. Though her letter mentioned the injuries that she allegedly sustained during her examination, it devoted most of its attention to the health center's lack of responsiveness to her complaints. It also included a general statement that she wanted assistance in receiving the restitution. The conclusion of her letter summarized what she was asking for. Quote, I've enclosed all relevant previous correspondence between UIC Health and myself and look forward to your guidance on how to proceed. Chronis also attached roughly 60 pages of documents relating primarily to the correspondence between Chronis and the health center. One of the pages included the fact that Chronis had previously sought $332 from the health center. Notice what didn't happen in any of the quotes. Now, I guess we could go ahead and assume that Amy Barrett just decided that not to include her actual request. Like, we could assume, for the purposes of argument, that Amy Coney Barrett selectively edited the letter in writing the opinion, which would be so ridiculous as to be absurd. It would be absolutely ridiculous to suggest that a judge would selectively edit out a portion of the letter while quoting it for the text. So I'm not going to do that assumption, and I'm going to suggest that the letter does not ask, it does not make a claim to the department. It mentions a claim, sort of, to the hospital or the health clinic. It doesn't make a claim. And I'm sorry for this. I really am. It sucks. It sucks when you do it wrong. It sucks when you do it wrong. Okay? But she did it wrong. Now, here's the best part. I want to point this out. The moment she was notified by the court that she did it wrong, she could have done it right. Are you with me? She could have just done it right. That's an amazing thing. Let's see. Did we have procedural, the history of this? Okay. Just a second. She lost this case September 8th of 2017. You have 2 years to bring a claim. 2 years. And that's not exhaustive since it's an administrative procedure. You can actually make the claim after the statute of limitations has run. But in September of 2017, she still had a year and 6 months. All she had to do at this point was send a letter to the department asking specifically for $332, and she didn't do it. She chose instead to appeal the decision. Why? They told you what was wrong.
And so they filed for a motion to dismiss the case, and the judge granted it. But Anna Chronis hadn't come this far to back.
He granted it September 8th of 2017.
Back out now.
Why? Why? She doesn't need to back out. All she has to do is send a letter or Form 95. The lower court told her what was wrong. They told her that she didn't actually submit a claim to the department. That's all she had to do. Just submit the claim. Just do it. If you haven't done it yet, they're not dismissing your existing claim. They can't. You haven't done it. The court just said she didn't actually do it. Legally, she has not done it at this point. It's not like the underlying claim is being dismissed on merits. The underlying claim hasn't been made.
She appealed that decision all the way to the 7th Circuit Court of Appeal.
All the way to the literal next step. Bravo.
Where it came in front of Judge Amy Coney Barrett.
And 2 other judges.
Barrett was appointed to the appeals court by the Trump regime in 2017. It has been quite difficult to write a video about her because the situation in the US is changing so fast. But
I mean, you have 3 years of decisions that she's made. Why is it hard to make a video about her? What makes it difficult? She hasn't been rendering decisions as the situation has changed. Literally nothing about her jurisprudence has changed since she was nominated to the time that she was appointed and then confirmed. In fact, in that entire time, I'm not sure she sat for a single case or wrote a single opinion. Maybe she did. I don't know. But even if she did, there's 3 years of previous work to be done, to be examined, or the 20 years of her as a law professor. Plenty of people have written plenty about Amy Coney Barrett very quickly from the time of her naming to the time of her confirmation. Why did you have so much trouble doing it? Why is that? I'm not going to say that he attempted to cherry pick a particular case and make much of it. I don't know that he did. What I will suggest is that he picked a poor one. I get the argument he's going to make. It's extremely faulty and problematic, but we'll get there.
But I mean, look, the script is clear. I'm just going to have to apply the original meaning of the text, even as the facts change and it becomes outdated. But
none of the facts have changed in this at all. Again, this is a snarky and pithy joke. Okay, I get it. He's ripping on originalism. But here's the thing. The underlying facts to this case have been settled since, July 29th of 2019 as far as the appeals court goes. So all of Amy Coney Barrett's involvement in this case was done a year and a half ago. A year and 4 months, we'll say. A year and 4 months ago, this case was done. Her involvement was done. Her opinion was published a year and 4 months ago. You have technically had a year and 4 months to explain this video. So no facts have changed in regards to this case. A subsequent thing that he doesn't get into is that this was remanded back down to the lower court. They attempted to ask for the statute of limitations to be extended, and it was denied. And you know why? Do you know why it was denied? Because Amy Chronis, not Amy Coney Barrett, Amy Chronis she put in the mail, the physical U.S. mail, her request, knowing that she was putting it in the mail on the date it was to be received, that it was due. And she attempted to use something called the mailbox rule to get around it, which does not apply in cases like hers. She waited a year to send the request. 1 year. Why? I don't know. She seems to be someone who routinely fails at doing the very bare minimum to get what she needs. But again, she waited A year. She was told on this date, you have to send this thing. That's when it expires. And on that date, she put it in the mail. She could have done it 3 days earlier, a week earlier, a month, 6 months, 9 months earlier. She didn't do it. Why? Because this person is allergic to doing things right. This isn't covered in the video. I wonder why. Why wouldn't he cover in the video the fact that Amy Chronis has just a penchant for doing it wrong? Probably because it undermines his argument about how important this $332 is to her, on what his reasons may be. Maybe he doesn't know. Maybe he doesn't know. I admittedly have research tools at my disposal, which may not be available to him. Oh my. We're back. We're back. We're not back. Okay. Okay, we're back, I think, now. Okay. We'll see how this goes. So what I was saying is I don't know. I honestly do not know if maybe he just doesn't have the research tools to look up the case after its remand. But I have them, and she failed. Entirely her fault that she failed. Entirely her fault. But we will go on.
Barrett is an originalist. Originalism is a philosophical method for interpreting the Constitution and laws of the United States. You see, in the US, they have this thing where 300 years ago, they were like, we want to be independent. And then we, the British, we were like, we're trying to save the world from Napoleon? We'll call you back. And then they did it. And then Thomas Washington.
I don't know if he understands that undermining his, like, jokingly undermining his understanding of the United States history and the Constitution's history doesn't benefit his argument in any way.
He wrote the Declaration of the Constitution. It's a special piece of paper. And then now they all have to do what the piece of paper says. And then they sang a big musical about it? Alexander Hamilton. I'm not sure that's right. I think I need an American.
Hello.
Ah, Devin, thank you so much. Whilst I enjoy this deliciously illegal haggis, would you explain to the boys and girls about Thomas Washington and the Constitution?
This'll be great.
Thomas Washington?
Thomas Washington?
I think you're thinking of George Jefferson. But yeah, the American system of governance is, to put it mildly, interesting. It is, as you probably know, a constitutional democratic republic. So we have a whole system of government, but theoretically at least, it's bound by the Constitution.
It's not theoretically bound by the Constitution. It is bound by the Constitution. That's... and Devin, I don't know why you say theoretically, at least, except to fluff out your stupid elocution style. But it's not theoretically, at least, bound by the Constitution. It's actually bound by the Constitution. The difference is not in the binding of the government. The difference is in the interpretation of what the Constitution actually binds.
That is the highest law of the land. And the American government has 3 branches of government. We have the legislative branch.
We actually have 4. Only 3 enumerated branches of government, but the administrative branch is considered a branch by many, many people, and not just cynics.
That is made up of the Senate and the House, which writes the laws. We have the executive branch that's headed by the president.
Oh, and by the way, if we don't have 4 branches of government, then the administrative state is entirely under the second branch, which is the executive branch, and entirely at the control of Trump. Yet, it's interesting that people like Devin don't want that to be so. So it must not be true.
Effectuates the laws. And then we have the judicial branch headed by the Supreme Court of the United States that interprets both the laws that Congress passes and also the American Constitution. And the Constitution theoretically provides an outer bound to what the entire U.S. government can or cannot do.
Cannot do. Cannot do. Doesn't provide a bound to what the government can do. It provides a bound to what the government cannot do. It's a series of negative liberties. And it's intentionally so. You can't do this. You can't do that. You can't do these things. It's a restrictive document, not an enabling document.
And theoretically, the legislature can't pass laws that violate the Constitution.
Now, theoretically, that's not true at all. The legislature can pass laws all day that violate the Constitution. Those laws will be stricken once the judicial branch determines them to be unconstitutional. Or actually, I don't know. Not even clear that they'll be stricken. They'll just won't be enforceable. But the Congress can pass laws that violate the Constitution. Nothing stops them. They have plenary authority to write a law, and then the president has plenary authority to write it into power. The only thing that can stop is the enforcement or enactment or enabling of the law, the execution of the law by the judiciary. If it's determined to be unconstitutional after a case with facts on the merits comes before the court. And only then, these people are, and again, this is sort of a fine summary for a 4th grader, but it's really not educationally viable for anybody who's trying to learn about this topic. And I'm nitpicking basic things, but that's because they're basic and don't actually take extra time to explain.
Nor can the president do action that violates the Constitution.
Yes, he can. They do it all the time and have for 230 years.
So there are advantages and disadvantages to this approach. If there are things that you think are really, really important and you're worried that there are certain majoritarian tendencies that are going to prevent those principles from being effectuated, then you might want to enshrine.
Stop using this language, Devin. You're speaking at a college level, but the education you're providing is elementary. Stop. It's just off-putting.
Those principles in the Constitution. For example, if you wanted to protect certain minority rights, then you might put those in the Constitution so that no matter how hard the legislature tried or no matter how whipped up the populist fervor was, they couldn't contradict the law of the Constitution.
What Devin has just forwarded is an originalist argument of judicial interpretation, and he's too stupid to know it, and so is Philosophy Tube. And that's the worst part. That's the worst part, because the whole idea of an evolutionary theory of the Constitution or a living constitutional document is that populism in and of itself, the changing morality and changing acceptable standards, the changing morals, mores, norms of culture dictate how we should view something. This is easily and succinctly summarized in a review of how the 8th Amendment, the prevention of cruel and unusual punishment, has been applied in recent history versus how it was originally written, okay? When it was originally written, when the Constitution was originally written, the only punishment for any felony act was the death penalty. That's it. There was no jail. There was no monetary restitution. Felony penalty was death for whatever the list of felonies at the time were. They clearly did not determine that that death penalty in and of itself was cruel and unusual. And guess what? They didn't have lethal injection. They had hangings. They had firing squads. They had a couple other methods. But long story short was there was no torture process. It tended to be a somewhat quick death, relatively, like we're talking a momentary sort of thing versus a protracted experience of death. All right. That was the idea. And by the way, yes, you could execute children. Yep. Down to as young as 12. As young as 12, you could execute them. There was no question about it at all. It was absolutely understood that the death penalty for people ages 13 through 100 was a perfectly acceptable form of punishment. Men, women, everybody. All right? Now, the current decisions about the death penalty involve that certain methods are deemed cruel and unusual. Methods of the death penalty. Now, there are no methods of the death penalty specifically stated or even referenced in the early founding of this country that are considered cruel and unusual. Death was the penalty. That being said, there are other decisions saying that we can no longer execute someone who, at the time they committed the crime, was under the age of 18. Again, that is not how it was written. That is not the original understanding. That is a fervor of populism that says that we don't want to kill children anymore, okay? Because people go, oh my God, a 16-year-old's being executed? I mean, that seems a bit harsh. That's a changing moral landscape of the country. Now, interestingly, you can just pass a law that says that we can't execute anybody under the age of 18. Congress can do that yesterday. They could have done that in 1802. It doesn't matter when they wanted to. They could have at any time passed that law. They never did. Instead, we relied on the courts to enforce the populist fervor that was not sufficient to change the minds of Congress. So, what Devin has articulated is an originalist perspective on the Constitution. If you're trying to enshrine certain things and set them aside to be maintained, that is quintessentially originalism. To read less than what is intended into the document or more than what is intended into the document at a later time due to cultural shifts, which is what Philosophy Tube is ultimately proposing, is an anti-originalist approach to the Constitution, which is fine. But my point is neither of them realize, and look at where Devin's eyes are. I'm 90% sure he's reading from a teleprompter. Neither of them seem to realize that Devin has actually forwarded an originalist reading because that is the natural understanding of how a constitution in and of itself works. That's the natural assumption when you're reading a document that is meant to set aside principles that are not to be crossed, is that those principles are to be maintained going forward into the future. If you aren't maintaining those principles going forward into the future, there is no purpose in having a document that sets aside those principles. Again, it's the natural reading of it. It doesn't mean it's the only correct judicial philosophy, but it's why it's an appealing judicial philosophy for many people, which we're going to get there. We're an hour in, and we're only 7 minutes into this stupid video.
But there are disadvantages to that as well, which is that if you really disagree with the ideas and principles that are enshrined in the Constitution, it's really hard to change those.
No, it's not. It's not hard to change them at all in one direction. It's very hard to change them in the other direction. If you want to remove a protection that exists, for example, your right to keep and bear arms, then you have to go ahead and amend the Constitution. Theoretically, according to someone like Devin. But that's how it's supposed to be. It's actually not hard to give people more freedom as you go. Like, for example, if you have a Second Amendment right to keep and bear arms, and they go, by the way, we're going to write a law that clarifies that this applies to personal tanks. That's fine. They can do that really easily. Simple majority in both houses, president signs it into law, done. Same as passing any other law. It's removing the set-aside protection. Because when you write a constitution or amend a constitution, you are removing the item from democracy. That's the entire point of doing it. You're removing it from the democratic process.
You'd have to amend the Constitution, which happens from time to time in the US. It hasn't happened in a while.
1992 was the last time. It wasn't all that long ago. It's about every 30 years. We're about due for one.
But it's incredibly difficult to do. Specifically, you have to have a supermajority in the House and Senate, and then it has to be ratified by 30.
Devin's quick manner of talking here from his script says that you have to have a supermajority in the House and Senate. And people may misunderstand that to saying you have to have a political supermajority, like supermajority of Republicans and Democrats, which isn't actually true. It's just a supermajority of support. And that's a key difference. If society is at a place, a populist wave, so to speak, it's never a populist wave, though. That's the trick. If there is a wave of populism overwhelmingly supporting a particular position, senators and congressmen from both parties can come together and resolve the issue. That's what they've done in the past. There weren't actually like, well, all of one party had both houses and the presidencies. Woo, we got it in. That's not what's happened. It's just because like things like limiting Congress's ability to increase its own pay during its own term. We looked at that and went, you know what? These guys are assholes, and it would really suck if they could increase their own pay in the year they're getting paid. That seems a little bit weird. And you know why we thought that? Because they were doing it. And we're like, wait a minute. That doesn't seem right. Let's go ahead and get this thing resolved.
38 of the US states. That's not the only way to organize a democracy, but that's the way the US has decided to do it. And you see this being played out in the news media all the time. So for example, the United States has the First Amendment, which ensures a number of different freedoms, but among those is the freedom of speech. So the US government cannot infringe certain rights of speech. The UK government does not have that particular protection, but the UK government generally protects citizens' right to speech through legislative acts and statutes and laws.
And herein is again a simple well, but the UK government does it. Do they? Does the UK government do it? Does Count Dankula feel free to have a little Hitler dog running around? Is he free to do that? Do you feel free to criticize Islam over in the UK? What about taking a picture and posting a picture of someone who's maybe been accused of like rape or beheading, one of those things, one of those unrelated crimes. Do you have a right to go ahead and post the names, identities, pictures of people accused of that in the UK? Is that a thing? And do you know why? Because the UK doesn't protect speech through its statutes and laws. The UK limits speech through its statutes and laws. By the way, the US limits speech through its statutes and laws too. You know what the US doesn't have? The US doesn't have a law saying, you know what, people can say whatever they want. They don't have that law. The US doesn't have laws that say the government can't come after you for saying whatever. We have a constitution that says that. We don't have statutes and laws that say that. Instead, we actually have statutes and laws that say you can't disseminate cheese pizza, for example. A law and statute I agree with, to be very clear. But we have that law. We have laws that say that you can't use profanity in places of public accommodation in some states, for example. We have laws that say that you cannot have an adult novelty store within 500 yards of a school, for example, even though those would all be protected speech. Though ostensibly, we have all sorts of laws restricting speech. The UK has laws restricting speech. I'm pretty sure. I'm not a UK law expert, but I'm pretty sure they don't have a bunch of statutes saying what you can say, just a bunch of statutes saying what you can't. But I'm open to correction. Because again, this is just my opinion. I'm not educating you on UK law. Just educating or or espousing, I guess, ideas about the general thrust of how legal systems work in democracies, or as in our case, constitutional republics.
The U.S. has those as well, but at the end of the day,
name one. Name one, Devin. What law and statute do we have out there protecting speech? Which one is it?
The First Amendment to the U.S. Constitution enshrines those particular principles in law, and it's very, very difficult to go against the individual right to freedom of speech.
It's less difficult than you'd imagine, actually, but okay.
Of course, there are counterexamples of this as well. A lot of people would argue that it's crazy that the U.S. has the Second Amendment, which allows...
Well, a lot of people would, Devin, or you would. Which one is it? I wonder which one.
Allows an individual right to freedom to bear arms, or at least that's how the Supreme Court has interpreted it.
That's not... I need a minute. I need a second. It's not how the Supreme Court has interpreted it, Devin. To be very, very clear, the individual right was enshrined in the document at the time the amendment was drafted. You see, under originalism, you don't need to interpret that which is. You can interpret an individual right? Like they could read something into the statement. They didn't need to, because under originalism, what you do is you go back to the time of adoption and you assess what the common populace understood was the protected right at the time. And the common populace in 1791 understood that their right to bear arms, to keep and bear arms, was the right to keep and bear arms. And what they understood to be arms was common use military items. Swords, sabers, knives, there's sticks, spears, bayonets, guns, repeating rifles actually existed at the time. Cannons, battleships, all of these things would have been understood that they have a right to arms. It doesn't say guns. It doesn't say firearms. This is an important and oft overlooked point. The Second Amendment doesn't say your right to keep and bear firearms or gunpowder propelled projectile weapons. It doesn't say anything about that at all. It's arms. What are arms? And it's not arms because that is, one, ridiculous, and two, not what was understood by the populace or the framers at the time of adopting it into the Constitution. Let me read a couple chats here. Those will cheer me up. Mars Ultor says, Nick, why are you bothering to refute this Fug's argument point by point when you could just show a pic of his face? We don't need to hear land whale Downey Adam Driver to know he's a frowning dist. Oh, no, because I need to. It's cathartic for me. Puggernaut says, is Brit Bong seriously going to contend that one has to jump through fewer hoops with the NHS to sue for malpractice and has a higher chance of winning? No, he doesn't ever say that. Also, doesn't this case on its own seriously undermine the argument for single payer? Yes. Yes, it does. Yes, it does. You don't want the government to be, you really don't want the government to be in charge of your health care in America. You don't want it. You may think you want it. You're like, oh, my government daddy gonna pay for everything. No. Until you have a problem and you need to get it resolved, or you need that second appointment in a week. You can't do it. Dinak 8 says, yes, I was talking about the beauty and the beta guy. I don't like doing this because it makes me feel like a gay op person, but this is too humble to ask. If you want to ask, go on his stream. That's fine too. I'll see if I can get in touch with him. I'm happy to have him pop onto my, if he's not doing a stream, I would love to have more people and ammunition to come on and just to hang out and chat. I'd like to get to know him. The Wanderer says in Toy Voice, Legal Eagle taught me all I know about being a cuck, the legal system, and how to pick good lawyers. Crumbly00 says, hello, Nick. I'm currently very drunk, and my father got married yesterday. I hope you have a good F day, and I love your roasting Legal Eagle Vire nice review. It's in all caps. And I tried to correct some things out. Thank you very much. Enjoy your drunkenness. Nova Zero says, Devin just had a testy pop. I don't know if you heard it, but he just had a testy pop. Devin's still going through puberty. He's a kid, Nikki. It's child abuse. Careful, careful. Actually, it all makes sense now. Justin Watkins says, UK will be reading the Quran in Parliament within 10 years. Headings on London Bridge will probably be back in fashion before long. Screw this guy. Sick of these tea-drinking snobs criticizing us as their country falls apart. Gerard Garvin says, just a reminder that Nick doesn't own fancy books or a suit. You son of a bitch. And Sakaki Onsai says, I do not know who this man is. What I know is that in my heart, in my very being, in the fiber of my drunken soul, this man deserves to be immolated in a blaze like my precious Dresden. Ach du Lieber! There you go. All right. I'm ready to get back to it. Now I'm calmed down sufficiently.
And there's not a lot that the legislature can do. Even if you assume that a majority of U.S. citizens were in favor of gun control, for example, which I don't know if it's true or not.
Oh, sure. Sure, then why are you throwing it out as just a random hypothetical?
Let's say it was true. There's not much that you can do.
There is much that you can do. You can just repeal the Second Amendment. You just write an amendment that repeals the Second Amendment. There's a lot you can do. That's it.
If the Second Amendment provides an individual...
And by the way, if a majority of people are in favor of gun control, then the majority of people can, without the government, control guns. Just don't buy them. Is this hard? A majority... If 99.99% of the population doesn't want guns, they don't buy them, guess who doesn't make guns? Anybody. It's amazing. You actually have the ability, as a society, to control this. It's called the market.
Right to bear arms. So a constitution makes change very, very difficult.
It doesn't, though. It doesn't. And our country changes, I mean, dramatically. Think 10 years ago. Just 10 years ago. 10 years ago, we didn't have Obamacare yet. Or no, it was just being passed. It was just being passed 10 years ago. A year before that, didn't exist. Everybody's health care cost a fifth what it does now. Your health care costs a fifth of what it does 10 years ago. Think about it. Think about how crazy that is. Gas 10 years ago cost twice as much. Twice as much as it does today. And that change happened really quickly.
which can be a pro and a con. And there's certainly a lot of people in America who think that the Second Amendment protections are actually even more important than the First Amendment protections. But that makes the stakes of who...
That's only because when they come to take away the First Amendment, the only thing you have left is armed resistance.
Who is on the Supreme Court incredibly important. There are 9 justices on the U.S. Supreme Court, and generally speaking, the U.S. Supreme Court makes decisions about interpreting the U.S. Constitution and often interprets the most important laws in the U.S.
They're not the most important laws. In fact, if you listen to Supreme Court justices, they'll talk about how they'll routinely talk about how the most important laws with the most impact actually are at the local level. Your city ordinances and your state statutes are far more important to the average person on the average day than any federal law, and much less the ones that are being interpreted by the Supreme Court at any given moment. Again, just flat out wrong. Just flat out incorrect.
And so who makes up those 9 justices can be very, very important. And that can actually change the understanding of what the Constitution means and what it stands for. And if you control the interpretation of what the Constitution means, then you can change the interpretation of what the Constitution does. And so you can imagine that if the stakes are that high, that if you are changing or at least interpreting the meaning of the most important legal document in the United States, that people are going to care a great deal about who is actually making those decisions and on what basis they are making those decisions.
Again, kind of, but he leaves out so much judicial consideration and what goes into it. It's like, again, both of these guys are under this weird assumption that a case just happens to show up in front of the Supreme Court, and then they go, how do we interpret this big idea? So what they're projecting to the audience is this idea that if a case on abortion comes before the Supreme Court, we're determining if Roe versus Wade was correctly decided, and that's it. But that's not the case. That's actually not the case. We know that Roe versus Wade was incorrectly decided because just about everybody with any sense agrees that Roe versus Wade was incorrectly decided, including Ginsburg, even though she agreed with the outcome, says that its decision wasn't good. It manufactured a right. It wasn't the correct way to go about doing what was done, but it was done. That's the thing. It's been done, and that has actually bound the court in a specific way through stare decisis. And through stare decisis, it really tips the scales of what can and cannot be done on the Supreme Court. Now, stare decisis can be overcome in various ways, and there's no check on the Supreme Court to say, whoa, you didn't follow stare decisis here. But on balance, it actually really makes a difference in the decisions that they're making. It takes a lot to undo stare decisis. And it'll take a lot to overturn Roe, Casey, and other types of cases like it. But these guys act like, well, if a case about abortion comes up, they're immediately going to overturn Roe and Casey, rather than saying that the court will look at the actual merits of the case and determine just how much of any decision that is made will impact those sorts of decisions, will impact precedent. To find that something was wrongly decided and therefore to overturn precedent, we have very, very few examples of that. Very few examples of Plessy versus Ferguson being one of them.
Thanks, Devin.
Sure, no problem. Happy to be here. Are you okay?
Yeah, I'm fine.
Look, levity is required. I get it. But these jokes aren't funny.
So, back to the story. Anna Chronis is suing Uncle Sam for her $332. The case has come before Amy Coney Barrett, and Barrett is an originalist. We have to be careful here, because there's originalism the theory, which is about interpreting the law, originalism the political ideology, which is about using the law to get what you want.
That's not what originalism, the political ideology, is about. That's something he's created. That's something that he has manufactured to flesh out his argument. Originalism is a judicial philosophy. That's all that we're talking about with Amy Coney Barrett. But if you create a second definition of originalism that has nothing to do with the actual judicial philosophy of originalism, then you can implicitly attach your new thing to an existing person. That's not explaining what originalism is, or even criticizing or offering input or making an argument about it. That is the fallacy of creation. I don't know, I just made that up. And now I'm going to apply it to him. See how it works?
And originalism the cultural vibe? And they all kind of blur into one sometimes.
Nope. They never blur into one.
Correspondingly, there's Amy Coney Barrett the judge, Amy Coney Barrett the political figure, and Amy Coney Barrett the cultural symbol.
Notice what he's done, right? He has now set up Amy Coney Barrett to have 3 split personalities who apply these different things in different ways. But we're not talking about 2 and 3, even though he's implying that 2 and 3 apply to Amy Coney Barrett version 2 and version 3. But that's not Amy Coney Barrett's words. That's Philosophy Tube's words. This is the fallacy of application, I'm going to call it. And that is where you create a thing and just apply it as you will, rather than rely on the actual person's underlying argument. Amy Coney Barrett's argument is not that originalism is used to get what you want out of the law. That is actually, I'm guessing, has never left her lips or the tip of her pen in any form whatsoever. Nor is whatever the third one was. I don't even remember what he said. But her philosophy on originalism is literally the judicial philosophy on originalism as articulated by her, by Antonin Scalia, by Justice Clarence Thomas, by, in some ways, by Neil Gorsuch, in some ways by Saul Alito, maybe in some ways by Kavanaugh, I don't know. But they're not all originalists. Some of them are originalist textualists. Some of them have dual sort of things. And textualism and originalism are different.
And they also blur into one. But I promised to try and be as neutral as I can.
You failed
let me
miserably.
give you the theory for now. We'll get to the other stuff. There's different varieties of originalism. It gets technical, but let me break it down real easy into 2 key points. Point 1. The meaning of the Constitution was fixed at the time it was ratified.
Yes, of course it was. It necessarily must be. For the record, that's not something that living Constitution theorists disagree with. The idea that it's fixed at the time it is ratified is consistent across the definition of Constitution. It's what makes a Constitution. Let me see. So the Constitution, just the definition of Constitution is a body of fundamental principles or established precedents according to which a state or other organization is acknowledged to be governed. All right? That's it. It is setting a thing. And necessarily, if you're setting a thing by which something is to be governed, it must be fixed at the time it's ratified. It is necessary to the process. Now, the difference is going to come on point 2. Although he's going to make a difference of point 1, I think.
Let me ask you this. It sounds like a real philosophy jack-off
The only philosophy jack-off here is you, buddy.
question, but What does the word meaning mean?
This is the fallacy of meta-interpretation.
Put yourself in Anna Chronis' shoes, thinking about her $332 and the Federal Tort Claims Act. She might wonder, what does the law mean for my case? I.e., what's gonna happen? She might wonder, what did the authors mean when they wrote it? What were they trying to do? Or she might ask, what do the actual words mean? When the law says Americans have the right to bear arms, does that mean arms as in weapons? Does it mean arms on their bodies? Or does it mean they have a right to bear arms, the arms of bears?
Again, one of those is sensical, and the other two are nonsensical. Let me just pose a question. Is it possible that following the Civil or the Revolutionary War, that there might have been an amputee roaming around America? And is it possible that the men who drafted the Constitution and the Bill of Rights, who many of whom were generals, captains, or just soldiers in the Revolutionary Army, might be familiar with someone who was missing a limb, for example, just hypothetically? Now, knowing that not everyone has arms, because they might have lost one or two of them, would you enshrine a positive right to your literal appendage arms in a constitution? Something that a state could not guarantee. It would be impossible, because people can be born without arms. People can lose arms in accidents. People can lose arms due to crime. Is it just even remotely possible that maybe they were considering arms as in the weapons that military, or not even militaries, but just generally that people use? The right to arms, the right to defense. Something, by the way, the English notoriously took away right around the time that all these guys were leaving England. And that the very theory of tyranny of a monarch was driving this document's drafting. I mean, it's maybe. And that maybe the Bill of Rights itself lays out the specific things that tyrants are likely to do. Take away your speech, take away your religion. England had a mandated, Church of England that you had to be a part of. You had less rights if you weren't. Take away your guns. Take away the press. Take away what? Oh, put soldiers in your house. You want a real watch party? Well, we will watch you from your home. You think maybe the unreasonable searches and seizures, were they concerned about a police force that they were going to make? No. They're concerned about the traditional tyrant models of governance that they have seen and lived under and experienced for the past forever before this. And they looked at the things that tyrants do. They take away your due process of law. They take away your right to face your accusers. They take away your right to adequate representation. Fourth, Fifth, and Sixth Amendments. Why do they exist? Cruel and unusual punishment. They didn't want to be tortured by a tyrant. These are obvious things. And by the way, the existence of the Eighth Amendment basically precludes the idea that the Second has anything to do with your literal arm.
When originalists like Barrett say the meaning of the Constitution is fixed, they're talking about that third kind of meaning. What do the words actually refer to? You can look at the text itself to figure it out, or other historical documents that might shed light on how the words were used at the time, but according to the law, Anna Chronis has to exhaust all administrative remedies before she can sue Uncle Sam for her $332.
If you haven't figured it out yet, because, and I know this is not a slight to you, because I was like, what is this guy ultimately getting? This guy is going to argue that Amy Barrett's decision in Chronis healthcare, or Chronis versus United States, is due to originalism. And that if she just wasn't an originalist, that she would rule the opposite. That is, I don't know. I don't even know what to call that, but that is an incorrect assertion. First of all, even assuming that you're going to rule that Amy Barrett is reading the Tort Claims Act in an archaic way and that the meaning of all administrative remedies is somehow up for debate, if you're going to argue that that is the premise, or that is the basis of Amy Barrett's decision, and then you say, well, another view would, you have to show how another view would necessarily come to a different conclusion to make the assertion that the originalist approach is definitively incorrect. Even if your opinion on how it turns out is what's driving your analysis, which is, this is what his thing is here. He's mad at how this turned out and suggests that the correct thing would be to just give her $332. And it's a real easy thing to say, right? It's like, it's the federal government, just give her $300 or whatever. That makes sense. It'd probably be resolved. And they probably would have if she would have just done the bare minimum and done what they asked. Just do it. But once you sue, you've done something. You've activated a process by which you can't just resolve things that easily all the time, and especially not when a government's involved. But I'm getting too far away here. A non-originalist can come to the same conclusion that Amy Coney Barrett did in this case. Because not only does her opinion not, let me see if original is even in it. Original image, and then no claim to original. So there is no use of the word original or any word with, a suffix like originalism, originalist. There's no explicit reference to original in the document at all. 0. She does not explicitly reference originalism as her interpretational lens for figuring this out. Lots of judges do. When they're raising constitutional questions or questions about the intent of statutory interpretation, they will talk about the original intent or the original meaning of the words. That's not in here. So she doesn't explicitly reference originalism in the document. He's making that up. And I thought in philosophy we weren't doing that. I thought that's kind of the goal of philosophy, is to avoid making things up. This isn't a hypothetical. He's not posing it as, let's say Amy Coney hypothetically applies original meaning to this. He's suggesting that she did. And because she's an originalist, she got it wrong. But she doesn't explicitly reference it. It's not implicitly referenced either. There's no statutory interpretation that's going on here. All administrative remedies is actually pretty clear. Is there an administrative remedy? Was it exhausted? In this case, all literally means one. There's one administrative remedy that she had to do, and she didn't do it. It's not like she did 10 and there are 11. There's one remedy, and she didn't do it. There's no quibble about what all means. That's not a thing. Not even in the dissent. The dissent's point is that pro se litigants should be given some extra leeway. And they should determine that her letter was, in fact, some sort of request. Because she's unrepresented and because the law is really confusing. Aha! But you'll say, Every time you represent yourself pro se in court, what do? They inform you of just how complicated the law is and that you'll be held to the same standard that a licensed attorney would be, and you're recommended to receive representation. They do that for the very reason that you are held to the same rules, even though you're not, even though you are given some leeway in this. The problem is it wasn't leeway she needed. She needed to just do the thing, and she didn't. That's like, okay, it's the difference between you go to Disney World and there's 10 roller coasters or whatever. I don't think Disney has 10, maybe Cedar Point. You go to Cedar Point and there's 10 roller coasters and you ride 9. See, man, I rode all the roller coasters at Cedar Point. You say it because you didn't really want to ride the little kids one or whatever, right? So you say, man, I rode all the roller coasters. What you meant was all of the big ones. Or you go to a county fair that has one little crappy roller coaster and you ride it and you say, I rode all of the roller coasters that are there because there's only one. There's a big difference between those two things. We're not talking about that. Anna Chronis didn't ever get there. She didn't ride the one. She didn't ride any because there was only one roller coaster. She walked up to it and went, nah, I'm going to go complain to the ticket booth. That's it. All right.
So the question is, what exactly does all administrative remedies mean?
It means all administrative remedies. If there is a remedy to be pursued administratively, as in by asking the administrative branch or the administrative agency in charge of the question for the remedy, if you did it. That's it. It's not even complicated.
And if you were in Anna's situation, you might well think, why do we have to have a debate?
Anna can't do the one thing she needs to do. She is clinically and chronically allergic to doing one thing. Even after being explicitly told how to do it, she doesn't do it. Anna doesn't even know what a debate is. She's demonstrated no cognitive function beyond literally waking up and going to sleep during the day. She's not into the meta principles of debate about what all or what administrative means. She does, because they told her. They said, you just had to do this and you didn't do it. You can go do it now. And she didn't.
About the meaning of words? Can't we just try and address the problem?
Yes! That's all they want you to do. Try and address the problem. But you're not trying to address the problem. That's the issue that we have. And again, that philosophy tube doesn't see it. It's like you went to a diner and you ordered pancakes. God, I'm gonna buy these pancakes and then eat me some damn eggs. And you're like, what? And then you get your plate of pancakes. You're like, there's no eggs here. I'm like, well, you didn't ask for eggs. You asked for pancakes. Like, but I wanted eggs. Like, well, if you want eggs, just ask for eggs. We'll make you eggs. Did you ask for eggs? No, I want to talk to a manager. For what? Just look, literally, all you have to do is just say, I'd like to order some eggs. And our cook will make eggs right there. He'll make eggs and take 30 seconds. Take 30 seconds. No, I want to speak to your manager. I didn't get eggs when I ordered these pancakes. And then the manager comes out and is like, look, I'm really sorry, but, to take your order, our waiter has to get some eggs. Has to get the order for you. You have to ask him for eggs. Do you want to ask him for eggs? And like, I'll think about it. And then they wait until the restaurant closes. And as the restaurant closes, they say, hey, I want some eggs. And they're like, we're closed. You had all day. You got here at breakfast. You had all day to ask for eggs. Oh, we told you just ask for the damn eggs. We'll give you eggs. And they wouldn't do it. And now they're mad that you're closed. And you're like, but we're closed. I'm sorry. The cook went home. He can't make you the eggs. And you're like, son of a bitch. And then Philosophy Tube does a video about it. This is where we are. This is actually what happened.
But I will tell you why with a controversial example. The Affordable Care Act, also known as Obamacare, was an American law passed in 2010. To a haggis-eating foreigner like me, the US can seem a little bit medieval at times, because they still don't have free healthcare over there.
You don't have free healthcare either. You subsidize it through taxation.
They still have the death penalty.
Yes. And it should be expanded to British philosophy tube.
And apparently, a truly worrying number of Americans sincerely believe that James Corden is funny.
He's yours!
Obamacare was supposed to fix the second most serious of those issues.
It literally was not.
It was very complicated, but the basic idea was the new law required Americans to buy health insurance.
That's not free healthcare. I don't know if you caught that. I don't know if you caught that. But we don't have free healthcare. Requiring us to buy it isn't free. That's not free. And again, this subtle misunderstanding of a basic concept is why I can't even take this guy seriously for a moment.
Whilst doing some behind-the-scenes fiddling to try and make it cheaper.
How did that work? What behind-the-scenes fiddling? What did they do behind the scenes? Tell me, Philosophy Tube, because I know what they did, and it wasn't behind the scenes. It was in an open public meeting. It was in an open public meeting where the lobbyist for the health insurance companies stood up and said, we're not on board unless you force everybody to buy it. Because this may shock everybody, but the individual mandate was so controversial that it wasn't in the original plan. Let me repeat that. The individual mandate wasn't in the original plan because they didn't quite think they could pull it off. So a lobbyist stood up, though, and said, the insurance company will back you, will back this, will advertise it. Remember, they all jumped on board. Blue Cross, Aetna, UCare, all those places, they're like, hell yeah, we love this Obamacare thing. Why? They negotiated in an open public meeting through a lobbyist, the thing that all Democrats hate, remember? All the Democrats hate lobbyists when they're for the guns. They hate lobbyists, but they had a lobbyist stand up and say, we're with you if you make everybody buy our thing. Well, la-di-freaking-da. Look, I will make this toy if you force every person to buy two. Oh, damn. You just guaranteed me 350 million sales times two or whatever. What a great deal for me. That's why they did it. And that's what they also did to make it cheaper. That and flooding it with a bunch of government money. It didn't make it cheaper. It raised the price immediately between 20 and 60% per person. That was the first year. It's only gone up since.
If you didn't buy health insurance, then you'd get hit with a penalty, which, crucially, would be added to your taxes at the end of the year.
Crucially, again, this wasn't the government's argument. This was the argument of the amicus attorney appointed to represent this aspect that the Supreme Court requested. The government's argument wasn't this at all. It wasn't in their plan. It wasn't some well thought out thing. It was an accident. And the only reason it accidentally occurred this way is because they already had a money collection arm of the United States government, and that is the Internal Revenue Service. That's it. That's the entire reason. That was the mad brilliance behind all of it. It was like, well, we can just ask the IRS to collect this penalty fee administratively rather than taking people to criminal court. Because you know why? Do you know why? Do you know why the fee was administratively? Can you guess why the fee was administratively being taken by an existing government agency rather than the criminal courts? Because it's a crime, right? It's a crime to not buy health insurance. Why aren't you charged with one? Oh, it's an administrative fee. Oh, because there's no way they would get away with criminalizing a non-affirmative act in that way. There's no way they could do it. They were terrified. Guys, even the Democrats knew the individual mandate was suspect. They knew it. They didn't want to do it because they thought it would sink the law. It might. It still might. It's still a problem. It was struck. I think the individual mandate was actually was already struck from it. Now the question is whether or not the law can stand without it. That being said, there's a reason they were scared of it. They are dumb, but they're not dummies. They know the challenges of this shit. They knew it the whole time.
Immediately, several people sued the government and said, hey, you can't make us buy stuff, man. You can't have a penalty for not buying health insurance.
Right.
The Commerce Clause of the Constitution explicitly says, and I quote, up yours, pal. The case went all the way to the Supreme Court, and after a bit of a tense back and forth, Chief Justice Roberts said, ooh, lads, well, yeah, the penalty for not buying health insurance is unconstitutional under the Commerce Clause. But what if, for the purposes of law, we called that penalty a tax? Because it's collected with your taxes, you see. And then that way it would be illegal under the Commerce Clause, but it would be fine under the taxing clause. Bob's your uncle, Fanny's your aunt, enjoy your healthcare. And some people, including Amy Coney Barrett, said, hey, that's cheating. You can't just stretch the meaning of the word tax like that. You can't make the law say whatever you want.
I don't think that's an actual quote of Amy Coney Barrett. In fact, when Amy Coney Barrett references Roberts' decision, do you know who she quotes in saying that the decision is the least sensical meaning of the term? She quotes John fucking Roberts in his own opinion, you dumbass. She's quoting the actual opinion. That's the criticism that she levels. It's not actually criticizing Roberts. It's using his own words to describe his own opinion. She actually said this and expressed it at the hearings that I wonder if you watched. I don't know. But she laid out specifically. When I wrote that, I was actually quoting the opinion, which refers to it as the less sensible reading of the text, because it was a less sensible reading of the text. That's not actually a criticism of the document or the ruling. That's a quote of the ruling applied to itself. It was self-critical. Roberts knew what he was doing. And I'll bolster my argument with another quote from Roberts in that opinion. It is not the job or duty of the Supreme Court to rescue Americans from the consequences of their elections. There you go. That's what Roberts was doing. He was not going to be on a court that illegitimized Obamacare based on party lines. He wasn't going to set the judiciary against the Democrat-controlled House, the Democrat-controlled Senate at the time, and the Democrat president. He wasn't going to do it. Consequently, Republicans won the midterms and took, I believe, the House and the Senate, maybe. Later lose the House again. You've simplified the story, yes. You've taken out all of the context and all of the meaning from it. And you've misapplied Amy Barrett's talk about it with a criticism of the decision itself. And the criticism comes from the opinion.
I've simplified that story, but that's an example of why people really care about this stuff. Point 2. The original meaning of the Constitution is binding now.
Yes, this is the point of contention between the two. He's actually, like, he made a whole lot about the first point, but the fact that it was set at the time is necessary to the idea of doing it. By the way, when a law is passed, its meaning at the time of passage is set. Of course it is. That is irrespective of whether or not you change that meaning later, or that you interpret it differently later. When a work of fiction is written, its meaning at the time is set. Its understanding at the time is set. That doesn't mean that you can't use different critical theories to derive other meanings from them later. Like taking this out of the context of law and into the idea of like critical literary theory, or even critical philosophical theories. Like if you're going to go in and criticize Plato, for example, you have to do two things. You have to realize that what Plato said at the time he said it was set. Of course it was. And it's set in the understanding of Plato. Now you can read back and say, well, this does or doesn't apply now, or teaches us something about ourselves now, or doesn't, because the meanings of these things have changed over time. You can certainly do that. The difference being the original intent of Plato's writings are academically important, but they're not relevant to applicability today. Applicability of those things now is just a matter of personal interpretation. You can derive whatever value you want from Plato's writings and apply it to your own life in myriad ways. And there's no real harm to anyone for that. However, the applicability of a constitution today does have a real impact that is binding in law. This is why you can't just mix the idea of philosophy with judicial philosophy, because reading something back and you can apply any ism you want: feminism, presentism, historicism, textualism, geography, or geographicism, whatever you want to do. You can apply those things. Genderism, racism, you can read those things back into a text and derive different meanings from them. You can do the same thing with law. But if you use that in the application of law now, by reading in something that wasn't when it was written, then we get strange and very often crazy results. That's the problem with sort of the living constitution theory, is that if we apply critical literary theory to the original writings and we try and derive new meaning from them, intentionally derive new meaning from them, we will get absurd results. And that's why the judicial philosophy of a living constitution, why those evolutionary ideas are contextualized and constrained by particular popular movements at the time. And those are manifest in the arguments, the public policy arguments that are being made before the court. It's not like they're grabbing all this stuff out of thin air and just doing whatever they want. Even the living constitutionalists aren't doing that. They're constrained by various things. Also, their colleagues' input. And for better or worse, the popular input of society. And the realization that Congress could always just write another law and change it.
I can already see you typing that comment. The number of people I've seen saying things like, oh, but according to the original meaning of the Constitution, women shouldn't even be allowed to vote. And it's like, yeah, nice tweet, Chief, but I gotta tell you, the Constitution includes all the amendments.
This is the fallacy of the retarded argument, okay? So he makes a ridiculous statement that most people don't actually hold to be true, especially anyone even mildly educated on the subject who would be debating it in a serious manner. No one thinks that the 19th isn't part of the Constitution. Many people might think that the 19th shouldn't be part of the Constitution, and that's a different question, all right? But no one believes that it's not the original meaning of the one document ignoring all amendments or whatever. The thing is, though, the 19th is fixed at the time the 19th was adopted and ratified.
The 19th Amendment explicitly says, and I quote, "Votes for chicks? Yeah, whatever, I guess." This point is more subtle than it might appear, and it's often misunderstood.
By the way, the one thing that he's doing, and this is really annoying, is by never actually quoting anything when he's being cheeky, you never know when he's quoting something. Remember this? Remember this giant bibliography? Can you pick out a single thing he's quoted in it? What's he quoted? He doesn't have the Constitution listed in here. So what's he quoted? We won't know, because all of his quotes are obtuse.
It's not saying that the intentions of the people who wrote the laws are binding now. That would be ridiculous. Who knows what various members of Congress intend when they make a law nowadays? Never mind Benjamin Hamilton and Slave's Blood O'Houlihan 200 years ago. Instead, Barrett says what's binding is the original public meaning. How did...
That's not actually what Barrett says is binding. And this is a misrepresentation of originalism. In any method of interpretation, you go through a list of things that you have to assess. And originalists favor the original meaning of the text. The original public meaning for some originalists. Not everyone, I guess, believes that, but that's the idea. You favor that. You say that that is important and informative. It doesn't mean it's the only way to look at the document. It doesn't mean that that meaning is binding. It means that that is an extremely important thing that they did. And it often results in trying to stick with that original meaning. But an original meaning being binding doesn't necessarily mean anything if the Constitution is silent on the issue at hand. For example, is a particular firearm permissible under the Second Amendment? Well, if that firearm didn't actually exist at the time of drafting, then the original meaning, the original public meaning, is only informative. It can't be binding. That thing didn't exist. So you have to then apply that original meaning to the new circumstance. And we see this with speech all the time. What about speech on the internet? Can the government ban you for saying things critical of the United States on the government's Twitch account? No, they can't. But Twitch didn't exist at the time of drafting the First Amendment. But when the government had control over a method of public communication, it didn't matter what that method was. They weren't allowed to do it. But so the original public meaning of the right to free speech is such that if the government has control over your speech, they can't really stop you from speaking. That's just the idea, but it's not a binding principle. It's just the informative idea. Then they have to determine if Twitch is that public forum. Maybe it's private. And good arguments that Twitch is private. But anyway, I'm getting too far. This guy...
Did the public at the time the Constitution was ratified understand it? Almost everybody agrees that the original meaning of the Constitution matters at least a little bit. If a judge sat down and said, "I read the back of my shampoo bottle this morning, and based on that text, I have made a decision," everyone would be like, "No, you have to read the special piece of paper that Washington James Lincoln wrote."
Is it funny yet? Is the joke funny yet that he doesn't know anyone's name?
God damn it, why did we even do that musical? Originalists go one step further, though, and say that the original public meaning is the...
Wait a minute. He is citing some stuff up here. Oh my God, I didn't even notice. Okay. So he is citing some of his stuff up here.
Most important thing to consider. Not just something that, you have to know it, but like other stuff's important as well, maybe? No. You have to stick to it. So here's the million-dollar question. Why? Assuming that there is such a thing as the original public meaning, which... and assuming...
There is a thing such as the original public meaning. It would be the prominent meaning at the time of adoption as recorded in various popular and critical literary texts. I mean, that's it. That's it. That's how they do it. You may not like it, but that's how they do it. There is a definition of what the original public meaning is. They look at legal commentaries. They look at social commentaries. They look at academic publications. They look at common law precedent that predates the Constitution. They look at all of these things. They look at, I don't know, the Federalist Papers.
Assuming that a judge was a good enough historian to find it, why should it be binding now?
Are you assuming that the judge isn't a good enough historian to find it? Like, what is it? That's the contrary is just as ridiculous. It's just as ludicrous. And the fact that judges publish their opinions, they're published. You can go find them. You can check their work. And if it's not correct, you can request reconsideration. You can move for an en banc hearing. You can go to the Supreme Court. And if that one's incorrect, you can take another case to the Supreme Court. There are all sorts of checks on this. But it's not just one judge. It's at minimum 5. At minimum 5 at the Supreme Court level. But it's not just 5. At minimum, we've had, what? Well, I guess the bare minimum would be 5, I guess, if they overturned completely every decision below them. That would be the bare minimum of judges. I mean, they happen to be what we have all decided are the best judges because they're the ones who determine what the law is, as we state. So they're necessarily the best ones. They have to be because their word is the law. So even if they're not technically the best, they are in effect the best. They are the superior judges, the supreme judges. And it takes a minimum of 5 of them. So it's not like they're doing this in a vacuum. It's not like one judge is sitting around going, oh, I Google searched history and found this. That's not how it works.
Maybe all administrative remedies meant one thing at the time it was written, but why shouldn't we interpret it differently today if it helps?
Hold on. Federal Tort Claims Act was written in 1946. Are we seriously going to argue that the Federal Tort Claims Act, written in 1946, that the meaning in 1946 of all administrative remedies is sufficiently different today than it was in 1946? Is that what we're arguing? Now, I know not everything from 1946 to today is the same. But we're going to argue that all administrative remedies, 3 basic English language words that have not changed significantly in meaning in any capacity from 1946 to today, which is, by the way, post the expansion of the administrative state that happened through the 30s. This is part of it. This is why it exists. It's an expression of the New Deal. Okay. Whew, all right.
And I get her $332. Why shouldn't we stretch the meaning of the word tax just this one time if it helps people get healthcare and saves their lives?
It doesn't help her get health care or save her life. She lived clearly fine. She suffered $332, she alleges, worth of damage. That is a de minimis medical expense in 2017. It is basically the equivalent of going in for a checkup and receiving maybe a shot of some sort. It has absolutely nothing to do with her ability to receive health care, which she got due in part to the Federal Tort Claims Act. It's not just the Federal Tort Claims Act. What's the other act? I'll tell you. It's the where is it? It's it. Hold on. I'm trying to find it. What the other act is. This is probably a waste of time. But there's a particular act that's implicated here as to why the state is actually doing this, and that's the healthcare one that I was talking about. I'm trying to find what that one was called. This is it. No, that's not it. Okay, I'm not going to find it easily. It's in one of these cases. I don't remember. Okay, whatever. Doesn't matter. There's the specific act that allows the hospitals to act on behalf, basically to act without filing for malpractice insurance, and then sends the claims to the federal government, is not the Tort Claims Act. The Tort Claims Act is what she's is the issue here, but there's a reason that you can do that in the first place, and that's not the Tort Claims Act. It's something else. But whatever. I'm just pissed.
I mean, consider this. The original public, at the time the Constitution was ratified, was a tiny slice of the population. It was white male landowners and almost nobody else who got to decide what went in there.
For reference, at the time of adoption of the Constitution, that was a very big portion of the United States. White male landowners were a large portion of the population. It's not like that was a rarity.
Far from being the product of democracy, the first Constitution of the US was the product of the violent suppression of democracy.
Nope. It actually wasn't a suppression of democracy. And it's not the product of democracy. It was, again, the product of a constitutional republic, because the delegates were sent by the sovereign states to the Constitutional Convention. They were representing people. It was a representative republic that was created, not a democracy. It wasn't created by democracy. In fact, white landowning men didn't vote for this. I hate to break it to you.
Including slavery and genocide. And if working class...
Slavery and genocide had nothing to do with the adoption of the United States Constitution. I guess at your best argument, you could suggest that the slaves weren't allowed to elect a representative. But again, slaves were a minority of the population. They were. And a pretty significant minority as well. Like, it's hard to overstate, like, how much of a majority white landowners were. Now, I guess you're restricting women, but if you're arguing suppression, you have to argue that these people were advocating for their right to vote and it was being suppressed. It wasn't. There's very little evidence that I'm aware of at the time of the drafting of the Constitution that women were clamoring for a right to vote and participate in a representative government. Maybe I'm wrong.
Class white people, black people, indigenous Americans, women had gotten a chance to write.
Wait a minute. Working class white people did have a chance because at the time, the working class owned land. This guy, like, does he think there were a bunch of rental high-rises or something going up? I mean, sure, you could find tenement farms or whatever, I guess, or indentured servants. But again, we're talking about the overwhelming majority of people at the time in 1790 were landowners. Because here's how you owned land. I don't know if you're aware, but in 1790, you just went a little bit farther west and dropped some sticks down and you owned it.
Right, some of it, it might have ended up looking very different. A lot of the original public owned slaves, so since when are we...
A lot of the original public owned slaves? A lot. Okay. What percentage? How many? Who?
Trusting those a-holes to know the meaning of cruel and unusual punishment, maybe we shouldn't be relying on the original.
Again, the meaning of cruel and unusual punishment, even accepting your premise, it's related to what the government can do to you, not what someone else can do to you. Slave owners weren't a function of government. I mean, they were protected by the government. Their slaves were insured by government. That was part of why the Civil War was fought, was because that insurance failed to materialize. Sure. But you can't just say a lot of them own slaves and then cruel and unusual punishment. What do they know about it? Well, to be frank, they were probably experts in it. And they said, we don't want the government to do this to people. That doesn't mean anything about what they want to do to people. Maybe that's a hypocrisy on their part, but importantly, a hypocrisy doesn't mean that their argument is wrong. In fact, I would argue that the people who enact cruel and unusual punishment are the people I want determining that it can't be done to them by their government. Because they might have a better imagination for it.
Original meaning. On the contrary, one law professor has suggested it would be better to presume that the original meaning is unacceptable until it is proven otherwise.
That's a ridiculous premise, and that law professor should be backhanded into a gulag.
An originalist could roll with that, though. They could say, yeah, all right, the first Constitution was a racist and even evil document, but it has since then been amended several times. It's better than it was. It might get even better in future, who knows? But the kicker is, it has to be amended democratically.
That's not what they would say. Again, an originalist wouldn't suggest that it has to be amended democratically. It would have to be amended through the original processes established in the Constitution itself. Though archaic they may be, democratic amendment of the Constitution would render it useless, because if 51% of the population could vote to amend the Constitution, we wouldn't have a Constitution. We would have a populist document that changes with the whim of the populace, with the whims of the majority. It's the opposite of what we're talking about. And again, These are basic things. This is not complicated. This requires no special knowledge. This is a basic problem with his argument. There's nothing democratic about the constitutional amendment process. Even if you don't go the route of getting it through supermajorities in the House and the Senate and then the ratification of states, even if you call a constitutional convention, your representatives to the Constitutional Convention aren't democratically elected. They're picked by the legislatures of the states and sent as representatives of the states to the convention. It's not a democratic process, because if it was, it would be meaningless.
For a lot of originalists, not all, but a lot, that's what it comes down to. The power to make laws belongs to the people and their representatives. Judges aren't elected. They're not accountable to anybody.
That's not true. Judges are accountable. They can be impeached. They can be, if a judge is bad enough, they can be impeached. Hell, one was. His name was Nixon. It was around the time, it was a little bit later than Richard Nixon, but he was a criminal. He accepted a bunch of bribes. And while in prison, he was still a judge, because you got to impeach a judge to remove them. Just because they're in prison doesn't mean they're no longer a judge. You're a federal judge for life until impeached. Guess what? They impeached him and removed him. Done. He was criminally prosecuted separate from the impeachment. The impeachment's a political process, not a criminal one. They could have, even if he was found not guilty, they could have said, you know what? This guy's a dick. And we think he was accepting bribes, even if we can't prove it. Let's remove him. They're accountable to Congress. The impeachment power. It's right there. And it's not even that. The whole point of that case was that he wanted a hearing before the entire Senate, like the president gets. Nope, not how it works. He was impeached and removed just by the Senate Judiciary Committee. They said, we've heard his impeachment hearing, and as a committee, we're voting to remove him. He's gone. And that was okay under the Senate rules. The Supreme Court upheld that. That was fine. Too bad, because there's no guarantee of having the full Senate sit for you as just an appointed officer of the United States. Only the president gets that.
So they can't just make the law mean whatever they want. If you want to change the law, there's a process for doing that. But until such time as it has been properly amended, the original meaning is binding.
But see, this is a misnomer. Oh, God, I hate this. I hate explaining this over and over. But it needs to be done. You can change the law all the time. The law is a big document, thousands and thousands of pages. It's changed with every act of Congress. It is sometimes changed by regulatory bodies in the administrative state with no congressional ratification and no presidential approval. And sometimes it's done by the president through executive order or by foreign agreements with heads of state. Like he can affect law in that way. It's changed in all sorts of ways. You're not talking about changing law. We're talking about a very limited section of the law called the federal Constitution. The U.S. Constitution must be changed in a very specific way. Other than that, you're free to change the laws as you please. But he's conflating the two because it makes his argument easier. All right? Because he wants to get to stupid points of progressive policies that are hard to get to, because it's almost like the founders thought, wait a minute, this is what governments progress to. Eventually, as they clamor for more power, they will do these things. We've seen it over and over and over again. We just got away from it. We don't want them to do these things. That's why they put them in a constitution rather than just writing a statute. You know what's amazing? The Constitution didn't have to say a single word that it says. And in fact, there's a maxim in the Supreme Court that says if you have words in the U.S. Constitution, they cannot be presumed to be frivolous or unimportant. It's that every single word and phrase in the United States Constitution is presumed to have intent, meaning, and import behind it. All of them. Every word is considered to be intentionally placed. Nothing is an accident. Nothing's a mistake. So, to suggest that that this limited set of documents is somehow like the same level as your average statute is flat out incorrect. And then to conflate the difficulty of changing this original foundational document with changing just general laws, to conflate those two as being equally difficult is similarly a problem.
On whose authority could you say otherwise? If it says Anna Chronis has to exhaust all administrative remedies, then I've got to be neutral. I can't bring my politics into it. My hands are tied.
Again, nobody is quibbling over the meaning of all administrative remedies. This is a straw man argument. It's a red herring. It's not in the decision or the dissent whether all administrative remedies mean something different. The question is what her letter was. What was the letter itself? What was the letter she sent? Was that a request for an administrative remedy or not? Amy Coney Barrett and one other judge say no. The lower court says no. One appellate judge says we should be lenient. Even though it doesn't request it, we should decide that it does because she's not represented by counsel. That's honestly the summary of the dissent. Is that even though this person is wrong, we should just decide that they're right.
Unless... What about precedent?
Oh, this will be great.
Precedent is all the decisions a court has made previously. Most legal scholars agree that that should count for something. In Anna Chronis' case, the dissenting judge, Judge Revner, cited precedent to argue that the court should be flexible because Anna was representing herself.
You know what's interesting is he cited the wrong precedent. He cited precedent that applied to a different scenario. Amy Coney Barrett also cited precedent. In fact, Amy Coney Barrett cites precedent that is almost exactly identical to this situation, whereas the other judge doesn't, which is explained in the decision. It's, Here, let's see if we can find it real quick. Here we go. I've got it right here, okay? Even liberally construed and read through the eyes of a legally sophisticated reader, Chronis' letter does not contain a demand for money damages in a sum certain. The closest that the letter comes to requesting any money at all is a vague request for help in receiving restitution. Perhaps recognizing that this vague reference falls short of the mark, amicus argues that by the way, she was appointed an attorney at the appellate level. So when it says she's a pro se litigant, I mean she is, but a very experienced attorney represented her interests as an amicus appointed by the court at the appellate level. She didn't make these arguments, he did. And both the dissenting judge and Amy Coney Barrett complimented the attorney on turning in an excellent brief and providing great arguments. So pretending that this person waltzed through this process with no representation is again only half true. You won't find Philosophy Tube talking about it though. Amicus argues that Chronis implicitly demanded a sum certain because one of the letter's many attachments revealed that she once sought $332 from the health center. But she simply attached this along with what Amicus acknowledged were as many as 60 pages of attachments as background information. And in any event, although the dissent makes much of these attachments, we have said before that we will not force agencies to search for claims buried within pages and pages of attachments. See Deloria versus Veterans Administration, quote, explaining that the claims that may be gleaned from a 63-page appendix to an administrative filing have not been asserted for purposes of exhaustion. Do you notice what that is? That is precedent exactly on point, almost to the exact number of pages. Almost to the exact number of pages. Now, he doesn't mention that Amy Coney Barrett cites precedent for exactly why they can't do this. He just mentions that the dissent has cited precedent for why they should, which is ridiculous. Let me see if they have the other. Let's see. So in the dissent, yeah, they have some other things, but they have some citations in there. She deals with them somewhere else in here, but it's not. Again, I'm not going to get into the weeds of the decision. It's not super important because the decision was a pretty obvious one. Did she make the claim? No, she didn't. That's all that was determined. She was told she didn't make the claim at the lower court. She was told to make the claim. She didn't.
So, for an originalist, what if a prior decision by the court, like, say, I don't know, the Obamacare decision, or Roe v. Wade and Planned Parenthood v. Casey, the two decisions that affirm the right of Americans?
They have nothing to do with Chronis, to be very clear. He's doing two different things here. But again, he's blending them together as if they're the same. They're not.
To get abortions? What if those precedents conflict with the original public meaning of the law? This is where Amy Coney Barrett, the judge, the political figure, and the cultural symbol collide.
No, it isn't. Because you've established that Chronis is an important review of originalism. The entire context of this video is originalism in the eyes of Amy Coney Barrett. And yet you're not talking about Chronis here. You're talking about Roe versus Wade and NFIB versus Sebelius or Obamacare generally, which Amy Coney Barrett hasn't ruled on those things.
I have done a video on abortion before, so I won't get into that topic today, but a lot of the media coverage about her appointment is treating it as a sign about the future of reproductive healthcare in the US. Barrett is a devout Catholic. She does believe that abortion is wrong. She has publicly stated that Roe v. Wade was decided incorrectly.
No, she hasn't. She has not done that. That is actually untrue. Do you know how we know she hasn't done that? Because the scrambling of the Democrat senators in the confirmation hearings to try and attach her name to those words failed miserably. She hasn't done it. He's just flat out lied and said that she said it was decided incorrectly. That's not what she said. That's not even what the statements she signed onto said.
Certainly a lot of right-wing people are very keen on the idea that she might help them ban abortion, and it is true that a lot of her previous rulings skew conservative. The vital question for millions of Americans that I'm afraid at time of recording I can't answer.
You haven't answered any questions so far. Why are you afraid that you can't answer this one? You should be afraid that you can't answer any.
Is, will those precedents stand?
You know who else can't answer this? Amy Coney Barrett. There's no idea. There's a lot of things that have to happen for them to even be a question of whether or not they'll stand.
There are some famous precedents that arguably do conflict with an originalist reading of the Constitution. The state of West Virginia, for instance, was officially recognized by a Supreme Court decision in 1871 and may, in fact, be unconstitutional.
It isn't. It isn't unconstitutional. You know why? Because the Supreme Court recognized it as a state in 1871.
Oh God, nobody tell John Denver. Oh, he'll be so upset. But of course, nobody's gonna try.
I wonder if this asshole gets content ID claims for that 4 seconds of John Denver.
And get out of parking fines in West Virginia by arguing in court that the state doesn't exist. And if they did, the prosecution would go, motion to dismiss?
If the prosecution moved to dismiss its own case against a parking fine in West Virginia, that would be for the benefit of the defendant, you dope!
And the judge would go, yeah, I dismiss you with this motion. Things like the...
No! In fact, if a prosecutor moved to dismiss a parking violation, the judge would go, oh, thank God, dismissed. That's it. It would be the greatest day in the judges' and the defendant's lives. They'd walk out. The defendant would go away, and be happy and would not pay a parking fine, and the judge would move on to literally anything other than what he's doing right now, which would make him happy.
State of West Virginia, the civil rights cases, these are what's called super precedents.
Only some of them.
They stay in place not only because the court agrees to abide by its previous decisions, but mainly because nobody challenges them.
Yeah, exactly. Not that nobody challenges them publicly, it's that there's no serious challenge. But what he's not going to make the distinction of here is that super precedent isn't like a legal term that matters. It's just a term that various people can apply to various things. So depending on the author of the super precedent statement, you're going to get a different idea. There are plenty of liberal scholars out there who would consider Roe v. Wade to be a super precedent because there's no serious challenge to Roe that exists at present. There are a lot of people who want to take it down, but the Supreme Court has rebuffed those attempts time and time and time again. And to think that suddenly they're going to change course is a hard thing to do. So they'll argue that Roe is super precedential. In fact, again, evidence of Roe being a super precedent in the eyes of many liberal scholars would be the gasping for breath reaction of the Democrat senators at the confirmation hearing over the idea that Amy Coney Barrett cited a paper in which Roe is not considered a super precedent. They couldn't believe it. They're aghast at the idea that someone doesn't think it will last forever. That's it. But the interesting thing is, it's just the author of that paper's particular concept of what a super precedent is that informs what cases they pick as exemplary of super precedent. And they decided Roe wasn't. And then Amy Coney Barrett cited it. Well, la-di freaking da. People do. Like, there's a public call for challenges to Roe versus Wade by roughly half the country every day. How can you say it's not contested?
The public has accepted the result. They are no longer controversial.
If Roe versus Wade wasn't controversial, why would you be talking about it throughout this entire video?
Okay, but what about Roe and Casey? Super precedent isn't a legal term. There's no protected definition. Some people say the abortion cases count. Barrett says they don't.
Barrett doesn't say they do or don't. Barrett cited a paper discussing super precedents. That paper had a list of cases and Roe wasn't on it. Barrett isn't making the case for Roe not being a super precedent.
Specifically because they are still controversial. Which is true.
That's all you need to say. It's true. It's still controversial. There's still challenges to it. States challenge it. Organizations challenge it. Lawyers challenge it. Individual plaintiffs challenge it. All of it. Both sides, by the way. Both sides. Do you guys know there are challenges to Roe and Casey for not going far enough? Because they do eventually say that states don't have to provide abortions past a certain point. They would want them protected up till the end of the end of birth. There are ethicists who argue that it should be after birth. It's not only conservatives who don't like Roe and Casey.
But so far, I've done my best to present originalism as neutrally as I can and to give it a fair go.
Remember when I said at the beginning that he's going to turn about 2/3 of the way through the video very specifically and admit that he's not being neutral? Even though at the beginning he says he's neutral. Here it is.
If you are a conservative and you've come this far, then I do appreciate you, and I hope that you appreciate my effort. But I'm afraid
I don't. Your effort has been shit. Absolute trash. There's no neutrality in it. There's no deference to the idea of originalism. It's not even adequately explained. You didn't do any of the research necessary. And you know what? You know what's interesting? I made a tweet below my show announcement tweet saying that he didn't seem to read any case law here. Do you know who one of the most famous early cases that goes to the original meaning and original intent of the constitutional grant of authority? It's Marbury versus Madison. It's one of the most important cases that exists. It's by and large a super precedent. It is the case where the Supreme Court takes the power of judicial review. It's where all of this comes from. And do you know where they derived their decision in Marbury versus Madison? They had to look at what the original meaning of a mandamus was, whether or not the Constitution conferred power on the courts to grant a mandamus to the Secretary of State acting on behalf of the president in conferring writs to newly appointed and confirmed judicial officers of the United States, or specifically the District of Columbia. It's one of the earliest decisions, and you know what they do? They don't say the words originalism, but they just go through and determine what the Constitution says they have the power to do as it's understood by the people who wrote it at the time that they wrote it. That's it. That's what they do. It's literally one of the earliest cases of the Supreme Court. It is originalism in a nutshell. And it produces kind of an absurd result. That's it. So here we go. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. The rule must be discharged. There you go. They applied the original meaning of the Constitution. Judicial review, constitutional affirmation by a Supreme Court isn't in Article 3 of the Constitution. But originalism determined that that's what they meant Article 3 to be. But I don't know. Maybe originalism, he's going to explain in just a minute where originalism came from. Wait till you fucking see it.
There's a point at which trying to be neutral becomes hiding the facts.
That is not true at all unless you are overtly biased and attempting to present something dishonestly. Being neutral would be actually presenting all of the facts. It's the opposite of what you just said.
I can't educate you if I don't tell you the truth, the whole truth, and nothing but the truth. And the truth is, I could not find an academic or journalistic source that was neutral on originalism.
Now, again, interestingly, whether or not he can find an academic or journalistic source, didn't he criticize earlier a judge's ability to find an academic, find a proper historical definition of something? Your inability to find it doesn't mean it doesn't exist. Also, the neutrality of your source material is irrelevant to whether or not you can present something neutrally. And thirdly, the neutrality of source material is irrelevant to the underlying value of the concept or validity of the concept. So just because something is controversial and that there is no neutral opinion on it doesn't mean that it's invalid. I guess it's the fallacy of confrontation, since we're still making up fallacies. I'm committed to the bit. Let me have it. There's nothing that says something must be a non-controversial to be valid. So this is pointless.
The theoretical, the political, and the cultural are all muddled up all of the time. At least some people are drawn to originalism not on its merits as a theory, but because they think it'll get them what they want.
So here again, he's saying that they're all muddled up all of the time. They're not actually all muddled up all of the time. Some of them are muddled up some of the time. Maybe even the majority or most of the time. That isn't something we can quantify at all. But this video isn't about originalism in isolation or as public policy or anything like that. This video is about Amy Coney Barrett and her view of originalism and how it's applied legally. What he again has done is what I referred to earlier as a fallacy of application. He has just added in 2 extra parameters that he created and applied them to Amy Coney Barrett, disregarding her actual statements about originalism and her judicial application of originalism. He is predetermining that she must be using originalism to get to an answer that she wants, rather than using originalism and arriving at a conclusion where she arrives. Those are different things, and he is trying to subtly suggest that she is doing it in this way, even though he's not pointed to actual evidence that she's done it.
So abortion almost always comes up. For others, originalism expresses something like a
Again, the reason abortion almost always comes up is because the very language of Roe v. Wade creates a right that doesn't exist in the Constitution out of inferred meanings from the 9th Amendment that could not have possibly been meant by the founders at the time they wrote it. There is no way the founders meant it or the public would understand it in that way. Again, it doesn't make Roe v. Wade invalid, but it does explain why it's always brought up in a question of originalism. There is no plausible meaning or no plausible avenue to find that what happened in Roe was intended in the text. It just doesn't meet out anywhere. It doesn't, you can't get there. There's no way to get there. No one thinks that you can. The judge who wrote it doesn't think you can. Ginsburg doesn't think you can. Nobody who has honestly considered and read Roe versus Wade thinks, oh yeah, this is what they actually meant. The guy who wrote it doesn't think that. That's why they found a new protected right that only applies to a subset of a subset of a subset of the population. And that is pregnant women, subset of women, who are, women, subset of the population, who are pregnant, subset of the subset, who want to kill their baby, subset of the subset of the subset. They're the only person for whom Roe versus Wade acknowledges a right. No one else has the same right to privacy and body autonomy in healthcare decisions as a woman who's pregnant who wants to kill their baby. Try and find it. The government is in your shit right now. Try and have a private right to go to a doctor for a specific treatment about the COVID that you're harboring in your body that you want to kill in a specific way. Try and do that and see if the government has no right to know about it. You go into a doctor with harboring an organism inside your body right now, incubating it. Go into that doctor and try and remove it and see if you have a protected health interest in the privacy of discussion between you and your doctor. I fucking dare you. Argue under Roe v. Wade that you do, and they'll laugh in your face. But it's true. It's true.
Distrust of big government or a reverence for the founding fathers. You could, in theory...
It's not reverence for the founding fathers. They got tons of shit wrong. Tons of shit wrong. They could have cleaned up that language. Like the other day, Ty was on stream talking about how smart all these guys were. No, they could have been much more clear and explicit in their language and really solidified some things for us. Like say, we mean that the government will not take weapons away from the people ever, under any circumstances ever. Not when they're arrested, not when they're charged with a crime, not when they've served time, not when they're from another country, not blah, blah, blah. They could have done whatever they wanted. They could have done it. They didn't do it. Would have been nice if they did, if they would have clarified it out. But life doesn't work that way. So again, it's not reverence for the founders. It's recognition of what they created, recognition that they democratically, through representatives, removed things from the discussion of law. They removed from democracy a set of ideas and principles that must stand for the republic to stand, and that can only be changed under the most critical of circumstances. That's what they did. To say anything else about it is reading more into it than is necessary. It's not reverence. It's just recognition of what it's supposed to be and the underlying purpose of it.
Theory make an originalist argument for progressive causes, and it's not unheard of, but
Brown versus Board of Education was determined by an originalist reading of the 14th Amendment. You twat, to put it in British terms. Can be... Like, that is originalism to progressivism. They said that he's going to talk about it.
The data shows that the majority of originalists are conservative.
Because the definitions of originalism and conservatism are almost inextricably intertwined by necessity of their shared values. Conservative means to conserve what we have. And it's not like resources, it's values. Conserve ideals, conserve laws, rights, privileges, immunities, to conserve these things that we hold to be important. That's what conservative means at its base value. Originalism looks to the original meaning of a thing at the time of its creation. Therefore, if we're looking to the past for originalists and valuing what was done in the past, and then as conservatives looking to the past to derive value about ideals, then we're going to be going down the same highway with maybe slightly different off-ramps down the road. But that is a different proposition. Originalism isn't conservatism, because conservatism looks and holds on to values, but originalism takes things at the time of their adoption. So, for example, a conservative, in theory, could be, like if they're a radical conservative, could say that women don't have a right to vote or be in leadership positions because they take an ultra-conservative view of Paul's teachings in the New Testament. And they say that women are not to do these things. Okay, fine. An originalist says, I look at the original meaning of the 19th Amendment at the time it was adopted, and it says that no one shall be denied the right to vote based on their gender or sex or whatever. So then, they can't reconcile the originalist position with that conservative position. They can't do it. It's not a possible reconciliation, because originalism doesn't go, well, but before the amendment to the Constitution, they meant this. It doesn't matter. It was amended. So they're linked by nature of their functions, but they're not the same thing. But it's not that originalism exists because conservatives want originalism. It's just that the two philosophies, the two sets of ideas, have very similar applicative principles.
And I think I can explain why. I think originalism wants to be neutral, and it appeals to people who like the sound of that.
Nothing could be further from the fucking truth than what he just said. Originalism is not about neutrality in the slightest, but it's not about political motivation either. You can't be neutral if you advocate that the older position, the original position, is more valuable than a current meaning. That's not neutral, but it's also not politically left or right.
But it puts a veneer of neutrality over what is, in fact, a very political way of looking at the world.
It's not a political way of looking at the world. It's a consistent structure of application. The thing at the time is the thing going forward. That's it. It doesn't matter if the thing at the time was left or right. It can't, because then you'd have to say that Brown versus Board of Education was a conservative idea because originalism looked at it. It's apolitical, but it's also not neutral. But shockingly, neutrality doesn't hinge on left versus right politics. Much of the world doesn't hinge on left versus right politics.
When Anna Chronis' case came before Amy Coney Barrett,
what will this have to do with originalism? There it is. It's either a 0 or his anus. I don't know.
she upheld the dismissal.
Oh my God!
She said that letter, with the 60 pages of attachments, did not count as making a claim, and therefore, going by the meaning of the words of the law, she had not exhausted all administrative remedies.
He's really stretching for this. She doesn't say, going by the meaning of the words of the law. She doesn't say that at all. Like, it's not based on the past meaning of the words versus a present interpretation. That's originalism versus evolving. And this isn't a constitutional question. This is a statutory interpretation question. And originalism is a constitutional judicial principle. Statutory interpretation is different than constitutional interpretation. He probably doesn't know that, and because it kind of gets into the nitty-gritty thing here. But statutory interpretation looks at things like legislative intent. Originalism doesn't look so heavily at legislative intent because it's harder to find evidence of legislative intent in the Constitution itself.
What makes Anna's case particularly interesting is it came down to the original meaning of her letter.
Of her letter, which, again, is not originalism. We're not asking what the public at large thought about Anna's letter at the time that she drafted it, which, by the way, is way back in the historical world of 2017. You've just established that originalism is a question of meaning at an original time of creation versus the time it's being read. But by the time Amy Coney Barrett is reading Anna Chronis' letter, there is no significant change in the meaning of her words. It doesn't exist. Again, an originalist versus a living textualist or whatever is not going to necessarily come to different conclusions on this case based over a difference of opinion between the meaning of what she wrote in 2017 versus the evolved version of what she wrote in 2019. In fact, the dissenting judge would agree that her words meant the same in 2017 that they do in 2019. This guy's argument has fallen to catastrophic pieces, but he's too obtuse to even understand it. This is embarrassing for a supposed philosopher who should be using logic to reach different conclusions. He hasn't done that. He's created an agenda and tried to ham-fist in an argument to fit it. That's a different thing. And they don't match precisely because they don't match.
Does that document with the 60 pages of attachments count as making a claim or not?
Can you determine if what you mean is the meaning of the words in the letter or the meaning of the word claim? Because you're articulating two different things and you're saying that they're the opposite of what you're saying. You're saying Amy Coney Barrett is focused on the meaning of the letter. And now you're saying that the letter, does it amount to a claim or not? Those are different questions, neither of which is implicated by originalism.
For Barrett, there has to be a correct answer. It is either a claim or it isn't, and her job is to find out which. She experiences it as a process of discovery. But the dissenting judge, Judge Rovner, argued instead that the court should decide to read Anna's letter as a claim. Not a process of discovery, a process of decision.
Right, and one is a correct way to do it, and one is not. If the court were to rule in favor of the dissent, then the court has the subjective interpretation of what someone wanted to be versus what happened objectively. That's the problem. The court is now subjected or is now in a subjective decision mode versus determining what the person did.
Presumably, that's how Anna experienced it as well. The judge decided not to read my letter that way. She decided to uphold the dismissal. The people who've taken...
Which one is it, buddy? Like, which one of these are you trying to make out? Let me read this quote from Amy Coney Barrett. Indeed, the letter showed that Chronis wanted something other than money from CMS. The conclusion of her letter said it best. She wanted, quote, guidance on how to proceed. Requesting guidance is different than requesting money, and we have emphasized that a letter requesting, quote, something other than money fails to constitute an administrative demand for money. See Con. Concluding that the claimant failed to make a demand because he, quote, was seeking something other than money, such as an apology for the misconduct of the arresting marshals or punishment of them or better training of marshals. Also citing Smoke Shop, quote, unfortunately for Smoke Shop, we have never held that a request for the return of property unaccompanied by a statement that the claimant would seek money damage if the property was not returned satisfied the money damages element. It's a really specific element. It's highly specific. You have to ask for money, and she doesn't. She, in fact, asked someone else for money and then asked the government agency for help. They're different things. They did the meaning, again, the meaning never changed. It wasn't anything to do with originalism. Okay. I got a couple things. I got a couple things to catch up on. Bad Vibe says Devin is making the case. These are a little bit back, sorry. Devin is making the case that we don't want someone like him interpreting the Constitution. True. Puggernaut says, what? The Constitution is being reinterpreted. Pokemon evolution theme. Constitution has been reinterpreted as Mein Kampf. Oh my god. Nix Hex says, this guy's ignorance, unfunny jokes, sight gags, and quirky lounge music make me finally understand why boomers hate millennials. Bad Vibe says, Nick, wouldn't the Constitution be treated like a contract and the interpretational philosophy apply in both contract and constitutional law? Yeah, similarly. Very similarly. That's close. CE says, Nick, politics are complicated and you need a high IQ and big imagination or agenda to make what he is saying up. Bad Vibe says, quote, you still have the death penalty. Me, quote, yes, we do, and this is why we have the Constitution. We make it difficult to convict. Synac 8 says, heads up, I wanted to make a comment about his music clip from Team 4-Star Helsing Bridge, a parody of anime, but Google decided to decline my card for some reason, even though I send you 2 other super chats. Weird. Very weird. Bad Vibe says, has this guy never heard of sharecropping? Working class in the 1700s were largely involved in agriculture. The economic differences existed, but were marginal at best. The measure of economic levels were largely educational. And Bad Vibes also says his argument is like claiming, quote, I should get a license because I passed the permit but didn't take the last step of taking the driver's test. Basically, he's arguing against process, which is the argument used for open borders. Angry Baneling, because it's Latin. That's why.
Taken part in the George Floyd uprising. Is there a problem with the text of the law as it has been discovered? Or is it that police officers decide to break it and other people decide to look the other way?
Did you see how everybody decided to look the other way when Derek Chauvin killed Floyd? When they decided to look the other way, where he was arrested, like almost immediately. He was charged faster than any police officer has ever been charged. The 3 officers with him are charged with what are probably frivolous charges faster than any case has ever been charged out in regards to cops in Minnesota, when they all looked the other way. And when all that happened, the rioting still went on. So, yeah, I don't think their question has anything to do with originalism at all, honestly.
Law professor Robert Cover said that laws are always part of a bigger story that we tell ourselves about how society should be.
Okay, so now that I see his citations in the top right, have you noticed, though, that, like, so he picks a line from that text by Robert Cover, okay? What does that line tell us about the text that Robert Cover wrote? Got nothing. I don't know. But he's picked a line from it. Okay. What's the meaning of that text? What does it have to do with this case? Is that a central theme or thesis of the text? And this doesn't just go for this quote. It goes for every one of them. It goes for every one of them. And I think this is a strategy that some people use to bolster an argument artificially. They've picked a selection of multiple texts and taken various small pieces from them without regard to whether or not they're relevant to the text or relevant to the topic. They've just said something. But is that helpful? Is that useful? I don't like this method of argument. And you can't just do this in law either. Like, you have to cite the principles you're trying to apply, the legal principles. You have to cite why those exist, by statute, by decision, whatever they are. But if you just start throwing in citations for various texts, the court will hate you. Like, for extra text, like, he could just say that Robert Covey says this. Doesn't have to cite to a paper about it. And what does that paper tell us about originalism? I don't even know. What's the paper called? Here we go. Are these in Robert Cover? Nomos and narrative. Okay. What does that have to do with originalism or Amy Coney Barrett?
He called that bigger story a nomos, or a world of meaning. Different communities have different worlds of meaning that are shaped by all sorts of things, including how they normally interact with the law. As an example, take the right to free speech.
Very helpful.
Imagine that me and Ben Shapiro were both given 10 minutes to make a presentation on the state of free speech in the US. Ben might talk about college campuses and cancel culture and no platforming and anti-conservative bias in the media and so on. But when it was my turn, I might talk about anti-leftist bias in the media.
Oh yeah, there's lots of that. Here's the problem. The type of... Well, I'm going to wait till he finishes his point.
I might talk about how free speech can be manipulated, how it can be threatened by corporate interests, or how there are tens of thousands of people in prison who don't get it. So we'd be talking about the same laws, but we have very different ideas about their value and how we want them to be applied, because we live in different worlds of meaning.
That's not actually true. It's certainly not necessarily true, and I doubt it's actually true in regards to him and Ben Shapiro. Because I think if he's talking with Ben Shapiro about, and I'm making an assumption here, about what free speech means, just because he brings up something that isn't in his political everyday, in Ben Shapiro's political everyday wheelhouse, and is instead more along this, Ben Shapiro is probably going to look at the underlying principle of whether or not the speech should be free. So if Ben Shapiro is talking about anti-right media bias, and he says, well, there's anti-left media bias, and Ben Shapiro would go, and I disagree with that as well. Like, that's a simple answer for him to do. He's not going to say, well, no, we don't care about that. We only care about anti-right bias in the media. He may take issue with the relative amounts of bias that are perceived, but he's not going to, I'm guessing Ben Shapiro is not going to say, well, you know what? I don't care about what biases you're facing. I only care about mine. That's inconsistent with the idea of free speech. And it would be inconsistent for this guy to do the same thing just because they're topics that Ben Shapiro brings up. So I'm not sure why he's bringing up this point. Again, it's irrelevant.
So, what kind of a world do originalists live in?
All of them. Every kind of world.
Well, supposedly a neutral one.
No, not a neutral one. All of the worlds. Any kind of world. An originalist judge is going to live in a very specific type of world. An originalist lawyer, a very different type of world. An originalist academic or professor, another very different kind of world. An originalist layperson, a very different kind of world. Might be a factory, might be a gutter, might be a third world. You don't know. You can't do this.
That was one of its great strengths, remember, is that it asks judges to put aside their political opinions and just focus on the law.
Actually, originalism doesn't ask judges to put aside their political opinions and just focus on the law. Judges are asked to put aside political opinions and just focus on the law. And in fact, all 9 members of the Supreme Court will lie through their teeth and say that they do, even though they largely come down on political lines a very high amount of times. But they don't do it politically. It's just that their judicial philosophy tends to produce a predictable political result or politicized result. It doesn't mean that Breyer's going, I'm a leftist, therefore I want to enact this leftist thing. Breyer says, I don't believe this is what we mean as a society when we're talking about these issues anymore, and that we have moved past this point and we need to apply the law in this way, kind of like this person did, maybe citing to international laws or other jurisdictions, or even citing to relevant cultural shifts. That's not because Breyer says, I want this to be left. Breyer just arrives on the left a lot because his judicial philosophy will lead him into this sort of pervasive left approach to society that's showing up in things like social media. But judges are all asked to put aside their political opinions and just focus on law. It's not originalism that does that. And why does he say it is? Because he wants his audience to think so.
We might not be able to agree on who the best presidential candidate is, but surely we can both see the same words written on the page. No haggis allowed. And if we want to change it, then hey, there's a democratic process for doing that. But here's the thing. If you're going to defer to democracy or the separation of powers as the true core of originalism's value, you'd better be able to prove, not assume, but prove that American democracy is working.
America isn't a democracy. We have democratic aspects to our selection of representatives. It's really crucial. No, you will not find a working democracy in America. There isn't one. And that's good.
If there are systemic problems with it, like the Electoral College.
By the way, England doesn't have one either.
like the fact that senators aren't assigned based on the number of people they represent, like the fact that Washington, D.C. and Puerto Rico don't have statehood, like the fact that the last two Republican
senators are determined based on the number of entities they represent. It's not the number of people. We're not a democracy. Senators represent states and districts. So since they represent states and districts, each one gets 2. That's it. The House is actually, the number of representatives are determined by the number of people that they represent. They are. It's just that number changes. And guess how we determine what that number is? Through our elected representatives.
Republican presidents have lost the popular vote. Gerrymandering, misinformation campaigns, voter suppression.
These are all done by both parties, by the way. Gerrymandering is done as part of a political process with democratically elected representatives at the state level. State level. The most democratically representative people are state house members. Like that's the most democratic that we really get. And they do the districting in each state. It's not like some unelected bureaucrats do the districting in the state. It's a democratic process. Gerrymandering exists as part of the democracy because the majority wants to write in a longer extension of their power. It's literally democracy to have gerrymandering. Majority rule. That it's the quintessential democratic idea of using the majority to keep out minority ideas. That's why our republic fights mildly against it. Misinformation campaigns are literal democracy. That's not a non-functioning aspect of democracy. It's a functioning aspect of democracy. It means that a person is given all the information they are willing to consume. All of it. Not a selected, approved part from the state. It's all of the information that they can consume is allowed to be consumed, and then they are enabled in making the decision following their own processing of the information, including a counter misinformation campaign. That is democracy. The only anti-democratic thing he's mentioned here is voter suppression, which constitutionally we have ruled out actual vote suppression. Vote suppression has evolved in meaning from preventing someone from voting to not making it easier for someone to vote. Those are different things. At some point, we determined that it is easy enough to vote, and any easier poses risk to the integrity of the process, and therefore, a limit occurs on how easy it can be. And in the US, it is really damn easy to vote. No matter where you are or who you are, it is easy to vote. The only persons for whom it is hard to vote have made it a hard situation themselves. Like they're going to college across the country and they don't want to drive back. And guess what? We made it easy for them because they can get an absentee ballot and vote anyway by mail. But seriously, they will not be satisfied until they bring the voting booth individually into homes. And even then, there will be some means of suppressing.
Foreign election interference?
Foreign election interference is overtly democratic. Overtly. Again, just here's a weird thing. Maybe this is a controversial idea, but other countries are allowed to talk about who they want to be president and work to make it so. And so are we in regards to other Democratic elections. We have put limits on what they can do, but largely, like speech-wise, if you're talking about a U.S. election, you're under the jurisdiction of the United States, under the jurisdiction of the Constitution, and you should have free speech. And people may not like it. They may not like that Israel is talking about a presidential election. They may not like that North Korea is talking about a presidential election. They certainly don't if Russia or China do. But they can. They can do it. That's democratic.
Any one of those would put originalism on much shakier ground.
Literally none of them, actually. None of them put originalism in any different ground at all.
From what I can see of Barrett's work and the work of other originalists, they don't really talk about those issues all that much.
Are you kidding me? Gerrymandering has hit the Supreme Court like twice a year. Like twice a year, though. The idea of voter suppression has hit the Supreme Court every year that I can remember. Every election, well, every federal election year. So every 2 years, voter suppression hits the Supreme Court. What is he talking about? What is he talking about at all?
And conservatives might say, yeah, heard all that before. Democrats weren't complaining about that stuff when Obama was president.
No, this is, again, this is a fallacy of attribution that I've made up. Again, don't look for these fallacies. They don't exist in the way I'm describing them. He's created a false argument. It's really just a straw man. That's what it actually is. It's really a straw man. And he's going to use it to justify his red herring in just a moment. But, first of all, Republicans aren't largely saying that. That's not the counter argument. The counter argument to what you've said is that you're just flat out wrong, and originalists deal with these issues all the time in published cases that are highly publicized, and a minor amount of research would find any number of them. Any number of them. Current cases. Cases from 2 years ago, 4 years ago, 6 years ago, 8 years ago, 10 years ago, 12 years ago. Hell, we can go back to voter suppression in 2004, Bush versus Kerry. And guess what? Originalists helped decide that case too. And the Voting Rights Act. The Voting Rights Act famously being upheld but maybe reduced or whatever. That was done with the help of originalists as well. They talked about the issues. They reasoned them out. It's been a big issue. It was an issue at Amy Coney Barrett's confirmation hearing. The idea of civic rights versus individual rights. She's literally talked about it on Capitol Hill during the time you were recording this video. But your review of her work doesn't find that she talks about it that much. They criticized her for talking about it in a case where it didn't even come up.
And hey, yeah, maybe you're right. But don't get it twisted. This isn't last week tonight. I'm not a Democrat. I don't like the Democrats. And I don't like Obama either.
Notice the zoom in on him there? It was real subtle. Here, let's do it again. Watch this. He's getting very important here. Notice the zoom.
I'm not a Democrat. I don't like the Democrats. And I don't like Obama either.
Then the cut. Then the cut back to the full shot. It's a very subtle zoom. Here's the thing. It doesn't matter if you're a Democrat. It doesn't matter if you like Obama. It doesn't matter if you like Democrats. Completely irrelevant to whether or not you're neutral to the concept of originalism, because originalism is not inherently Republican and not inherently anti-Democrat. They have nothing to do. You constructed a straw man and argued against it. It's one of the most basic and obvious fallacies. It's also a red herring because no one was asking this. You created the question, then answered the question as proof that you're doing this objectively, and that's embarrassing for you.
I like haggis. My point is, for originalism to appeal, you have to believe that all of those problems with American democracy aren't really that important.
No, you fucking don't. That's crazy. That's an absolutely lunatic position to take. And it's flat out dishonest. In no way do you have to even raise the question of the import of those ideas to be an originalist or not. And originalism absolutely has answers to those questions, depending on the specific facts invoked.
And that is not a politically neutral belief.
But that is a straw man I created, just like John Oliver on Last Week Tonight. It is not part of the question just because you constructed the straw man to knock it down.
Now, there's two ways of processing this.
Nope.
The clever
That is called a false choice fallacy. That's a real one. There is not always just two ways of doing anything.
way and the dumb guy way. The dumb guy way looks like this. Hear ye, f***ing hear ye. YouTube court is now in session. It's your boy, the Honourable Judge Ian in Drivel presiding. In the case of Drivel versus
I profusely apologize for this.
the United States and Amy Coney Barrett, these are the facts of the case, and the facts of the case are these. This Sheila wants to be...
Sorry. You may be tempted to dismiss this section because he's being obviously ridiculous. It's a reductio ad absurdum, right? That's what he's doing here. He's reducing it to the level of absurdity. But importantly, when he's done with this section, he will reiterate that everything he said was factual. And that's not correct. But he's trying to use the illusion of a reductio ad absurdum argument without actually using it. But then he'll rely on it to make his point. And his audience will forgive him because they have no idea.
Supreme Court Justice. She says she believes in the original meaning of the Constitution, and ladies and gentlemen of the jury, maybe you believe that. If you're a f***ing nobody
I won't bleep fucking retard when I talk about this guy.
seriously believes in originalism. It was made up by conservatives in the 80s.
Remember, he's saying nobody seriously believes in originalism, made up by conservatives in the 80s. He's going to say that these are facts.
And nothing good came out of the 80s.
Also false.
Apart from the movie Predator. Now, Daddy Drivel's done the research, right? You know, I always go the extra mile for the Drivel arm.
You notice what he's doing here? He's making it ridiculous that he's done the research for the Drivel Army or whatever. But it's right here. He doesn't realize that he's criticizing himself by putting in this stupid bibliography.
Army, and originalism is pushed by the Federalist Society.
He's going to say that's a fact. But, and it may be, the Federalist Society may actually support originalist interpretations of the Constitution. That doesn't make originalism wrong and doesn't mean that the Federalist Society created or controls originalism or originalists.
They're an organization of conservative lawyers and other dickheads. The Federalist was started with money from this asshole, John M. Olin, as...
This is a genetic fallacy. Again, both of these are genetic fallacies. The fact that originalism may be pushed by the Federalist Society doesn't make it wrong because its genesis is in Federalist Society ideas. And the fact that John M. Olin funded the Federalist Society doesn't make the Federalist Society or the reviews that come out of them to be false. It's also from Jane Meyer, Dark Money, which is an overtly political text about money in right-wing politics specifically, as was laid out on the Senate floor during the ACB confirmation hearings after they were invoked by Sheldon Whitehouse. But Philosophy Tube's done his research, right, boys?
As in, only an idiot would fall for this bullshit. Olin was a rich guy, multi-millionaire type.
Fallacy of wealth.
hated the government and loved free markets. But check this out. He inherited his company from his father.
Irrelevant to whether or not the market is free or whether or not he can be successful in pursuing the interests of that company.
And his biggest customer was the fucking government. Judge Dribble says,
So?
you're full of shit, mate. He was also guilty of being a grade A asshole. The Olin Corporation dumped toxic waste into the rivers.
Irrelevant.
They poisoned their workers, and they straight up lied about it. Motherfucker
Irrelevant.
poisoned the environment. I live in the environment. This guy paid to set up the Federalist to push originalism.
Again, a genetic fallacy that has no bearing on whether or not originalism is valuable or valid or pre-exists the Federalists and this. And if he created the Federalists to push originalism, it must have necessarily already existed. So choose your argument, pal.
On American law students, so the courts would rule in favor of him and his rich asshole mates.
That's not how originalism works, by the way. Originalism doesn't favor corporate interests by default.
They put on fancy seminars where they wine and dine judges. They even paid to sponsor university courses to push conservative propaganda to kids.
Yeah, and again, literally hundreds of organizations do this across the country for varied political interests. Doesn't make any of them invalid.
The defendant, Ms. Barrett, has been part of the Federalist Society twice.
No, she has spoken at Federalist Society events twice. That's not being part of the Federalist Society. I'm not aware of her actually being a member of the Federalist Society. And every single Supreme Court justice currently sitting, including ones who have just died over the past 10 years, has sat at a Federalist Society talk. Every one of them. All of them. It means literally nothing.
Originalism is a scam, bought and paid for by corporate interests. Oh, and by the way, Ms. Barrett, I know that you adopted 2 black kids, but I'm
Now he's going with the absurdity thing again, just to tip it off, to remind you that this is all absurd and he doesn't mean any of it, except when he will in just a second.
on to you. You're just trying to pretend that you're not racist, aren't you? Nothing gets past the drivelator. I find you guilty of being a piece of shit and sentence you to rack off back to where you came from. Amy Coney Barrett. Please respond. All of the historical facts there are true.
See? He presented it ridiculously to mask the fact that he's about to use that argument.
The Olin Foundation was set up explicitly to push conservative propaganda in universities. They did help set up the Federalists, who are one of the big pushers of originalism, and several Supreme Court justices, including Barrett, are associated with it.
All of them. Every single one are associated with the Federalist Society. Even the liberal ones. By merit of them attending speeches, dinners, whatever. All of them. Debates. Here's the thing. If you listen to any of the Supreme Court justices talk, any of them, about other Supreme Court justices, they all like each other. They all do. They're all friends. They all get along. They just disagree. They just disagree. Breyer and Scalia were friends. Scalia and Ginsburg were friends. Thomas and Breyer are friends. They all get along because they don't actually view the world like this. We view them like this. We impose our political philosophies on. You have to remember how ivory tower Supreme Court justices are. They literally go, their words are law. They don't make a fortune, but they make something like $300,000, $400,000 a year. They make a lot of money, a very comfortable living. They're well taken care of. They have Secret Service guards for each of them. They have clerks that do a lot of the grunt work for them, that help them, that become very good friends of theirs and go on to be very lucrative careers. By the way, a clerk a clerk for a Supreme Court judge goes into private practice making more money than the judge they served under. You follow that? So once you clerk for Clarence Thomas, for example, you will go get a job at a law firm in New York or DC or LA, and you will make more money than Clarence Thomas does in your first year out of that clerkship. So I want to get to the point that we impose these like divisive lines and battle lines on the Supreme Court justices. They disagree with each other on ideas, but they're not disagreeing with each other as people, and they don't think the other side is evil. But these guys do. And that's my point in all this is that's the reason that these guys will go talk at George Washington University, for example, or they'll talk at Yale or Harvard or wherever they go. They go talk, and they just go because they don't care. It's not about, well, is this a leftist institution or a rightist institution? Their words are the law. They're the best constitutional lawyers that exist, the most important ones, and what they say matters. So people want to hear from them, and they'll go and give their opinions. And they're not associated with those organizations. When they stop there, they collect a speaking fee, and they do the thing. They're just not. Now, if they did a speaking engagement for the Federalist Society, and then the Federalist Society has a case before the court the next day, they might recuse themselves due to a financial interest. Doesn't actually happen very often.
The dumb guy take is to therefore assume that they don't really believe it, that it's all just a conspiracy of elites, that Amy Coney Barrett is sitting at home going, ha 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 ha, secretly I don't value the Constitution at all, and I did adopt 2 black children so nobody could call me racist for I...
Again, he set up this ridiculous argument, but no one seriously considers the idea that she doesn't care about the Constitution or that any of these justices don't care about the Constitution. Like, again, this is a ridiculous argument that he's setting up to prove that the other way to look at it is the correct one.
I am not Amy Coney Barrett. Secretly, I am Lord Freezer. That's very comforting. It allows us to imagine our political enemies as evil, but unless you've got a camera inside her brain, there's no way you can prove that. The haggis pill take is that it doesn't really matter whether she believes it or not. This is an example of what leftists call manufacturing consent.
This is what you have done the entire video.
Ideas get spread regardless of how many people actually believe in them because it's in the interests of the people who own the airtime to do it.
This is not true. The problem is, when ideas spread, it is necessarily because people believe in them. Whether or not the originator of the idea believes in it is irrelevant. Whether or not the propagators of the spread agree with it is relevant, because if they don't believe it, the idea won't spread. Like, you can't spread an idea that no one ascribes to. They'll just ignore it. What you do is you convert people into that belief. It's a pretty important difference.
And until media is democratically controlled,
media is democratically controlled. Media is overtly democratically and increasingly democratically controlled now. I know we don't like when YouTube puts restrictions on us. I know. I get it. Believe me, I hate it. I hate that I can't call this guy all sorts of silly gamer words just because he's a nonce. I can't do it. I know that YouTube will censor it, okay? Like, if I get too spicy, they'll have to go. I'll have to go. I don't like it. But largely, the simple matter of left versus right is democratically available media all over the place. Anyone can start a YouTube channel and grow huge. Talk radio has been a way for Republicans or right thinkers to do this forever. Left thinkers have done very well in traditional news media, especially broadcast news media, through various methods of doing it. You can combat them People like Glenn Beck have shown that you can create a TV station and you can get it onto major networks. You can do it. You can do that. Al Gore did the same thing and failed miserably. You can do what Crowder has done and create a massive following that is a serious political entity. You can do what Rush Limbaugh has done. No one would seriously consider Rush Limbaugh a political media lightweight in any sense, and he's done it largely on his own ability to make content and then make deals surrounding that content. How are we going to argue otherwise? Media is more and more democratically controlled by the day, and as we break down the major institutions propping it up, I mean, YouTube is YouTube and channel and things like it are the ultimate democratic control of media, and they're increasingly becoming more and more important relative to traditional media, which is why traditional media is trying to be the corporate interest that controls the voices on YouTube through money. Ironically, that's what's happened. But that's a different topic. I will also say that democratically controlled media has nothing to do with the validity of originalism or Amy Coney Barrett's view on it. It's completely irrelevant. This is another red herring.
This is going to keep being a problem.
It will not.
Originalism may or may not be a scam.
It isn't a scam. In fact, the very nature of posing it as a may or may not question is dishonest. It's not a scam. People genuinely believe in originalism, and judges routinely apply originalism in published texts, and they're the only people for whom belief in originalism actually matters. So the fact that you can go to their published work, which is public published work, available and accessible to literally anybody for literal free, and find what originalists, the only ones that matter, believe on every subject that comes before the court, is counterthetical to your idea that it may or may not be a scam. It necessarily can't be a scam if it's in active employ right now at the absolute highest level of government, all the way down to your local municipal courts. So ridiculous concept he's pushing here.
But the marketplace of ideas definitely is.
And it absolutely is not. The very fact that you, an unqualified hack, can go on and I, an unqualified hack, can argue with you at our whimsy and generate relatively large audiences to what we'd be able to go outside screaming and garner shows that the marketplace ideas definitely is not a scam. It exists. There's just undue forces trying to control it in undue manners, and that's fine. That's also, ironically, part of the marketplace of ideas. When the marketplace of ideas dies is when government controls it, not when corporations have large financial stakes in it.
So when Barrett says that the controversy over Roe v. Wade has never really gone away, she is right.
No, he's got a but here, but there is no but. The controversy over Roe v. Wade has never really gone away, ever. From the moment it was decided through today, it remains one of the preeminent features of debate, of public discourse. It is probably the most controversial thing that is discussed in regards to government by volume of discussion. This is insane.
But maybe part of the reason that's true is because conservative media pundits and lawyers keep writing articles and funding cases to make sure that it doesn't.
Yes, that's how law works. But that's not the reason that people are opposed to abortion. Like, he has set up a fallacy, and he did it very subtly. I don't know if you caught this. I didn't on my first watch through. But he set up a very tricky thing of saying Amy Coney may not believe in originalism. Therefore, people may or may not believe in originalism. Therefore, it's irrelevant if people do believe in originalism, because in the absence of belief, ideas can be spread with moneyed interests. Then what he did was set up that Roe v. Wade exists because of moneyed interests. Therefore, its existence is not because people actually believe it, but because of an interested few's agenda. That was the fallacy that he linked there by putting those two things back to back and putting them and linking the language and the concepts in them. It was a nasty rhetorical device to suggest that no one actually cares about abortion. Roe v. Wade is just a moneyed political issue, fostered in part by a select few of people pushing it. And that is, of course, ridiculous. Just go ask 20 people on the street and you'll get 20 different answers about it. People do care about Roe v. Wade.
It's like lobbying, but instead of lobbying the government, they're like lobbying your brain.
It's actually nothing like lobbying at all. And they are lobbying... Well, no, let me correct him. Sorry. It is like lobbying, and they are lobbying the government. They're funding cases. They're pushing legislative restrictions on abortion in every state. They're trying to do it. And then they're trying to get those legislative restrictions to amount to cases that could overturn Roe v. Wade and Planned Parenthood v. Casey. It's literally lobbying the government more than it's lobbying us, because there is, as currently stands, nothing the Democratic public at large can do to overturn Roe v. Wade. We can't implement a ballot measure. We can't. If there was ability for a vote to overturn Roe v. Wade, they would have had it in 1974 and it would have overturned immediately. Immediately. The public support for Roe v. Wade when it happened was at its nadir, right? That's the bottom, I think. It was at the bottom. And they could have easily overturned it with a Democratic vote. They could have easily overturned it with a Democratic vote for the next 30 years. And only recently is that starting to become a question of whether or not Roe v. Wade would be overturned democratically. And it may still be able to, but there isn't a mechanism for it. So lobbying your brain has no value. And if you think the people who are maniacally smart and moneyed enough to determine public policy through shady backroom deals are going to waste that time lobbying your brain when it has no value to them, then you're an idiot. And I don't know how else to say it, but they won't. Of course they won't. It's a waste of time and resources for them to do.
So, my big question for originalism, and indeed all ideas, is, does this serve the interests of the many? Is this based in the world that most human beings have to live in?
It doesn't matter. It doesn't matter. Why is this a question that matters?
In my opinion, the answer is no.
Your opinion is irrelevant because the question is irrelevant.
My hot take is that originalism reflects and serves the interests of a very narrow and increasingly destructive top layer of society that is massively out of touch with how most human beings on Earth live their lives.
Let me point out something here. Do you remember at the beginning when he said he wasn't doing this politically? That was a political application applied in reverse to originalism. Originalism doesn't do that by necessity of its function. It doesn't. It has no relation to what he just said. Originalism protects, or I guess honors, the original meaning of a thing at the time of its adoption or passage. That's it. That's what it does. And suggesting that corporate moneyed interests were of paramount import in 1791, I mean, that's a challenging argument. I mean, the very idea of corporations has changed pretty dramatically. Pretty dramatically. And saying that originalism protects the current iteration of corporate interests would be counter to the idea of originalism, which would necessarily protect the original meaning of corporate interests, right? Like that's what it would have to be. Unless it doesn't do that. We're almost done.
We can talk all day about words losing their meaning, But I think that's a reflection of the fact that we are living in an increasingly unequal society.
The man invoked slavery earlier and says that we are living in an increasingly unequal society. Please let that sink in. At the time of the founding, those guys were all racist slaveholders, and now we're talking about increasing inequality.
In which there are no longer common conditions to which common words could be applied.
This is a nonsensical argument. I can't even begin. Like, he's introducing these at the end of his video, and he'll have very little, if any, discussion on any of these concepts. But I want you to understand how absurd it is to say that there is no common experience to which common words could be applied. None. I mean, the blatant idiocy of this statement is galling.
Take free speech, for instance. I have my perspective on it, but what about a man like Rupert Murdoch? He's so wealthy, he can freely speak to and influence billions of people with no democratic accountability or oversight.
You know what? Think of the irony of this. Think of the irony of this. This guy has an audience of 766,000 people and has, on this video released yesterday, in one day, this literal nobody has reached 218,000 people. This video will go on to probably reach eventually 500,000 plus people, maybe 1 million plus people. With what? What did he pay to do it? Nothing. Nothing. He didn't. I mean, maybe he'll do targeted ads. I don't know if that's his business model or not. But he produced the video. That's all he did. Rupert Murdoch, to reach the same amount of people, can't just... Rupert Murdoch's YouTube channel doesn't get this level of traffic. He has to spend money. This guy, through whatever force he has his education, his experience, his charisma, whatever that may be, his appealability to various people, like that alone has created a market of people who will listen to him that is actually bigger than Rupert Murdoch's direct sphere of influence. Rupert Murdoch has to spend money to reach the numbers of people that this guy reaches without a thought. And he's arguing that it's unfair for Rupert Murdoch to be able to do that. And that is lunacy. That is lunacy.
He lives in a different world of free speech.
Yeah, he lives in a world where his speech isn't free. He has to pay for it to reach the people that you reach for free. You're right. He lives in a different world. But it's not based on his wealth. It's based on the fact that he has not focused in the way you have on the things that you have and cultivated an audience that you have.
What hope of finding a neutral between us? What hope of finding a neutral meaning of police accountability between the George Floyd protesters and Jeff Bezos?
Jeff Bezos agrees with the Floyd protesters. What are you talking about?
A man so wealthy, he probably hasn't even seen a police officer in years.
I guarantee that's a lie. I guarantee Jeff Bezos has seen a police officer in years. This is lunacy. He's entirely in supposition right now.
Never mind been threatened by one. What it comes down to is this.
Really? Really?
Choosing a method of constitutional...
Oh, God, we're really close to the end, I promise. But let's examine this for what it is, real quick. Whether or not Jeff Bezos has seen or been threatened by a police officer in the past several years, that doesn't preclude him from coming to neutrality or commonality on ideas around police or police violence. Nothing about that is exclusive to that possibility. And he's provided no evidence for any of his positions. He's just said them.
Interpretation is also choosing how people will experience the law. And that prompts the question, which you should not answer in my comments section. Do you feel that the laws of your country are discovered for you or decided for you? Do you feel that...
That's not a question that you actually raised. He's hearkening back to his exploration, which I assume was basically zero, of Amy Coney Barrett's ruling in Chronis versus United States and the dissent's ruling, where he, through supposition, determined that Amy Coney Barrett discovered the meaning of the words, whereas the other judge decided the meanings of the words. But that isn't how laws are created. That is how laws can be interpreted in some instances. And that's a very, very different thing. And there's merits to actually having both of them. And we do, because Congress people decide what the law should be, and the courts discover what the law is. Since Marbury versus Madison, that's been the way it goes. And that's where his fundamental misunderstanding is that for all of his talk about democratic society and democratic selection, our democratically elected branches of government do the deciding. And our non-democratically appointed, and they're still democratically appointed, but justices on the Supreme Courts and the lower courts do the discovery. That is their distinct and separate roles. And it's that power struggle between those two branches which helps just a little bit in the fight against oligarchical tyranny from the government.
That they are within your democratic control.
They absolutely are. And it's important to remember, this is the craziest part of this. The only thing that a constitution does is restrict government from doing something. Okay? The things that are democratically within our control, like an abortion, prior to Roe versus Wade, any or every state, or even the federal government, could have made a law saying abortion must be legal through the first 2 trimesters. There you go. They could have done that. Every state could have done that. The federal government, through the Commerce Clause, probably could have done it as well. They didn't need Roe versus Wade to do it. Every state can outlaw the death penalty. Every state can say, not only can you not restrict soldiers in your home, but you can't deploy soldiers onto U.S. soil. Or you can't drive a federal military vehicle on an interstate, for example. Maybe they don't want it. Or maybe you can only drive them on an interstate. And they can't use side roads or country roads. They can't go into neighborhoods. Every state and the federal government, well, the states can't do that for federal vehicles, but they could do it for state police, for example. They can restrict it. Democratically, we have so much authority in lawmaking, but that lawmaking can't be used to restrict the people in very specific ways. This is the underlying misnomer of all of these discussions about constitutionality and about what power judges have. Judges can only further restrict. Like, they can restrict the government from making laws about legalizing abortion. But you don't need the government to make, or you don't need the judges to make a law about making abortion legal. Congress could have done that. And they can for anything. Anything. Again, they can make more guns legal. They can make more weapons legal. Congress could make a law right now demanding that the government buy a gun for every citizen and put it in their house. Congress could do that tomorrow. They won't, obviously, but they could. That's not a judge thing. And there likely wouldn't be any judicial review on it. If the Congress wants to create a budget item to purchase a gun for every American and the executive wants to sign that into law, what's the judiciary going to say? That's not a reviewable question at all. The only time that we're even dealing with questions of review are when a constitutionally protected thing is implicated. And those protections are ours. They're ours. We own them. We don't want judges deciding what the law is, Because judges will just create shit that doesn't make sense. We want them discovering what the law is, based on what Congress meant, based on what someone meant. That's what we want. We have these clashing branches of government for a reason, with different roles for a reason. If the judiciary is just an unelected branch of Congress with no review, then we're really sunk.
When you encounter the law and its enforcement, does it feel like something that's been shaped with your mutual consent through a process of rational deliberation in which you are an equal?
You're not. You never were an equal, ever. You were a tiny portion of a populace. But let's let judges democratically decide how they run their courts. Let's think about this for a minute. Because his alternative, a lack of originalism, is a terrifying proposition. Well, what does it mean, no unreasonable searches and seizures? I don't actually care what it means. I think this search is reasonable. I know there wasn't a warrant, but they found the drugs, so it was reasonable. And if you don't think that will happen, that did happen! That has happened! Over and over! That's why it went to the Supreme Court, and they had to protect what unreasonable actually meant, based on what unreasonable actually meant. Your due process rights. Well, I think it's fine that they held black people in jail for up to 72 days without charge. Because maybe they committed a crime and the courts were really busy. And if you don't think that'll happen, it did happen in California. That's why there's now a 48 and 36-hour rule about how long you can hold someone without charge and without probable cause. Those exist because in California, they would pick up a black guy and hold him for 30, 40 days without charging him. Just put him in jail. Because he was black. That's fine. That's what they did. Why do you think that judges said it was okay? That had to go up the chain to the Supreme Court for them to go, you know what, though? I mean, I don't think when they said that there's due process of law, that this is what due process meant. I think what they meant was you were afforded like some liberty rights here and some representation, the ability to get out of jail if you pass some qualifications. That happened because a judge first determined that it was reasonable for the worst thing to happen.
Or does the law feel strange, inscrutable, absurd?
These are the credits. I'm not going to go through his credits. You notice what he doesn't do there? He doesn't come to a conclusion. He doesn't lead to a conclusion. Well, he leads to and infers the conclusion that originalism is bad based on a bunch of things that have nothing to do with originalism. He doesn't set up the premise on why his closing argument is related at all to the idea of originalism, or more specifically, Amy Coney Barrett, which is the subject of the discussion. He doesn't do it. He just doesn't do it. But because he used floofy language throughout the entire thing, and because he has a British accent and had some spectacle going on with stupid music, with dramatic zooms, with cuts to Devon, with reductio ad absurdum, overproduced segments involving a fake Australian. Because he did that, people are left with a conclusion that originalism is bad because of something that they can't quite articulate. Because he hasn't done anything in the video to reach that conclusion. And that is why his video is worth fuck all. It's shit. It's drivel. It's bad. All of it. The spectacle, the inclusion of the musical interludes, the jump cuts. Do you notice at institutions of learning, universities, schools, or whatever, they don't educate like this? Do you notice that? That's because this isn't education. It's entertainment for some people. But there's a reason why, like, this isn't a popular method of education. It doesn't work. And he somewhere in that script lost what he was trying to accomplish. Because he doesn't get where he was going. You don't even know ultimately where he's supposed to be going. Because he never gets there. He doesn't logically connect his 4 sections into a cohesive whole. He doesn't do it. All right. Sprite Cola says, I'm so sick of this collectivist bull. This guy needs a brain transplant. To the street. Or whatever. Okay. Okay, guys. I've gone way longer than anticipated. You guys hung around way more than I thought you would. You showed up for way longer than I thought you would as well. So thank you for that. I'm going to read through Justice Chats and Super Chats. And then I'm going to, we're going to go over to Twitch. Like I said, I've got some time still. I'm going to go to Twitch and I'm going to watch Blue Thunder. Blue Thunder. Okay. So, that'll be fun. All right. On Your Knees B says, cutting out early tonight, drinking and work tomorrow, but I must say that isn't a bibliography. That is just a random assortment of links. Any moron can assemble a list of links without properly sourcing what they are pulling from them. Coleman says, why do all these figgy left tubers have cringy dress-up skits like it's a Nostalgia Critic episode? Likely because they share the same audience, children and man-children. Mercenary X says, first you ruined my night by revealing that Sean Connery died. No, I'm sorry, but that's not a spoiler alert. That happened yesterday. Now you're making me even more worse off by watching this Brit fig who deserves to be put to death via Golden Girls porn. But knowing this guy, he might like it. I need a more creative method. Ideas? Oh, I don't know. Maybe the chat has ideas, but I don't. Night of Hopex says, if you like the Smiths, I don't like you and I don't want you on my continent. Give in to the misery of life and cry yourself to death already. All you're doing is dragging the rest of us down, you sub-biological heap of carbon. Jeez. Meme says he is just another commie from the bread tube circle jerk. Same as H-Bomber Guy, ContraPoints, and the rest of their ilk. Have fun watching more of this garbage. Legal Eagles associating with him says a lot. I'm not going to be watching more of Philosophy Tube. Unless it's a specifically on-point video, and there... Oof, he did not make a strong case for me sticking around. Night of Hopex says, by the way, what he's inadvertently doing here when he talks about the democratic process not being effective enough is arguing against systems like communism and socialism, state-run healthcare, etc. If the powerful are unaccountable, why would we empower them? Yeah, but he doesn't see it that way. He doesn't see it that way. Kermit the Frog. What a surprise. History repeats itself and some self-important prick from England is trying to tell us how to live. Buy a hairbrush, asshole. Maybe invest a little bit of your parents' money in hair gel or just style it with your boyfriend's cum. Damn, Savage Kermit. Savage Kermit. Night of Hopex says, gotta take you to task on one issue here. Google is a quasi-governmental organization protected by 230, funded by the state, and has disproportionate pull over public policy. Them putting their thumbs on the scale of speech can be interpreted as state action. Can be, but hasn't been. Can be, but importantly has not been. So while it may be wonderful if we could get that to happen until it does, there is numerous precedent about no state action due to the mere presence of state funding if even a small amount of it is privately owned. Now, we may argue otherwise, but that's how it goes currently. Bad Vibe says, can we really say you were late and gay if you're 24 hours early? Yeah, that's a good point. That's a good point. Angry Baneling says, this was sent 5 minutes before you were late and gay rainbow flag. That all you had to do was press start stream. And Angry Baneling says, don't blame Susan. I know it's your fault. Rude. Belraven says, hey, Nick, it's day 2 of No Nut November. How are you faring? I failed it. I failed No Nut November approximately, what? Like, I think 8 minutes into November, something like that. It was very quick. Robert Levito says, hail, Nick. Thank you for accompanying me as I drive my semi tonight. May the dawn bless you. Hey, you too, buddy. Michael Mason says, don't forget to vote for Rogel Dorn on Tuesday. Hey there, Copper Cab. Don't worry, I've got a green hand job for you, buddy. Bad Dragonite says, the 5th Chaos God is Kermit the Frog. Joe Crazy says, hey, Nick, just got on the stream. What's that tool Legal Eagle doing this time? Nothing good. Nothing ever good. Ben Frail says, for YouTube philosophy, I like Keith Wood's channel. I don't watch any YouTube philosophy. I don't care. Angry Tism says, hi from South Carolina. Hope the election goes well and we can finally stop with all the damn political ads. Political ads are helping YouTubers a lot right now. Their per-click pay is really good. Hayami says, Nick, Sir Sean Connery just passed away yesterday at age 90. God bless the man. Thank you. Thank you. We covered that one earlier. Twilight Dragon 3 says, deranged horse. Does he know Monica Rial? The Dungeon Delver says, the United States fought a war against the British so we wouldn't have to give a damn about what they think about our political system. Copper Cab, I will sexually harass you all you want. Just bring those man titties over here to me. We'll fondle them like crazy. Let's see. Joe Crazy says, it's barely the beginning of the video and this red coat is showing just how full of himself he is. Copper Cap, don't make me bust out Elmo voices on you. Stooge Muffin Stuffin says, I meant chocolate. Oh, okay. Joshua Vidrain says, Brit Child Boy's face looks punchable. Don't mind me. Mario Carter 13 says, Legal Eagle's voice equals she want philosophy tubes tied. Kolfi 2A wannabe Hunan Muhammad says, F for YouTube's very existence. Nexi says, Legal Eagle plus philosophy tube reeks of smugness. Mario Carter 13 says, Arms Girl is constitutionally protected. No, she's not. Joe Crazy says, who hired this cod piece? Legal Eagle is a damn snake. 9Breaker2 says, does his video eventually get around to why Democrats need to pack SCOTUS in order to do exactly all of these things in their favor? No, he doesn't get there. He doesn't get there. Joe Crazy says, Lord, please take my soul from this plane of existence. There's only so much cringe I can take. Geekosity says, most don't know that ARMS stands for armaments, which means military weapons and equipment. They originally intended for all weapons the military uses. Bob Job says, I'm really scared about the odds that Trump loses. This election is making me very anxious. Any advice, Rackets? Look, if this is unpopular, but if Trump loses, you're going to be okay. I mean, for the most part. For all of the rhetoric about it being the most important election of all time, they say that every election. Don't believe it any election. It may or may not be. History will tell that story. We can't tell it in advance. For now, it's propaganda. I can't tell you Trump is going to win. I can't tell you Biden's going to win. I don't know. I'm the wrong guy to ask. But in the end, if Biden gets elected, things could be bad, but they probably won't be. I mean, they'll be annoying. We had 8 years of Obama, an avowed communist, and things got annoying, but things are relatively okay. Bowser, Spartacus of the Watch World. I mean, race relations are in the shitter, but, you know, that's something different. Bowser / Spartacus of the Watch World says, who would win in a fight, Ron Toye or this guy? This guy still.
Hey, Coppercap. Hi. I hear you like straight white males. I'm a little red, but I'm also a furry. I can tickle your pickle.
Bad Vibe says, uh-oh, Nick's getting itchy. Here it comes. Oh, I'm very itchy. Very itchy. William Jones says, I don't know what litter box you found this turd in, but he is sufficient justification for a third Anglo-American war against these whoresons. Damn. Mario Carter 13 says, it takes a very high IQ to be this stupid. Bad Vibe says, this British thing enjoys tea and crumpets with soy milk. Justin Bentley says, voting equals draft/fire brigade. Women didn't want that. Hell, women were questionable about the 19th Amendment for this reason. Classical Positioning says, I like Sargon. I've watched him for years, but I want guys like him and this dude to just move and get citizenship if they like our politics so much. Ryan Blue Thunder says, everyone buys Starlight Cats. It's super precedent. So there you go. Monica's personal effing fiance says, Nick, I'm feeling extremely jealous. Thought we had something special. Do you even care anymore? Please yell and curse at me for a minute. I need it. Who are you again? Automata says, a judge who decides her non-claim is a claim can also decide that my petition for redress is not a real petition for redress, despite what each says. Yes. Yes. Kimberly Moriarty says, here's some money for your suffering. Thank you, Kimberly. Thank you. Curtis Maunder says, sorry, we'll put him in the COVID gulag. Seed Fan. Wait, is he Australian? Seed Fan 85 says, I apologize on behalf of all Australians for foisting this drongo on you. Oh my God. Why did he set himself up as British at the beginning? Kidda says, there are three stances: left activist, neutral, originalism, right activist. The left is so used to left activist judges that originalism looks like right activism, some kind of twisted Overton window. Some kind of gold says, why do I sue over that racist depiction of my... Who do I sue over that racist depiction of my fellow Australians? Coppercab, you missed it when I had my hair actually cut with the proper fade. Goodness gracious. And yes, weaponizing sexual depictions of children's TV show characters is my favorite thing to do. Chase Weiler says, I drunkenly passed out for a bit there, but waking up to Nick's voice was the best wake up I've ever had. Andrew War Snowboard says, I 100% understand why Rupert Murdoch needs a thought to reach people. Chase Weiler says, listening to Mio Honda's Step in the background helps make this video, as well as Legal Eagles videos, more palatable. I would call for an English genocide if they weren't killing themselves. Damn. Uncivil Law. Hey, what's up, man? He says, react to epic rap battles. Biden versus Trump might help to ease the pain of Philosophy Tube, or at least have some fun. Well, not tonight. Not tonight, but we'll see. Easy 007 says, bring an Englishman. Being an Englishman, I disavow this idiot. This guy probably supports the new Scots, hate speech laws, family snitching on each other for edgy speech. Kidda says, the attempts to argue meaning reeks of postmodernism, which is Marxist gibberish at best. Lulzy King says, are you sure, Rackets, if Toye had a remote, I think he could take him? Well, that wasn't in the original question, and we've got to go to the original meaning of the question. Flamenco says, Philosophy Tube literally bragged about his YouTube subscriber count in a letter to his alma mater in an unsuccessful attempt to get a speaker deplatformed. Also refused to pay rent despite making upwards of $15,000 a month on being a pseudo-intellectual. That's sad. That's sad. That's not Coppercab. How dare you? First of all, that's not Trump, and that's not the God Emperor. That is his Nancy son, Rowboat Girly Man. I cannot... This? You called that offensive? You're offensive. How dare you? How dare you try and peg his identity into God Emperor Trump? He doesn't identify or express that way. You are anti-LGBTQ+, Coppercab. I cannot believe you. May Death Watch ask questions of your Xenos type. All right, guys. There we go. That's the video for tonight. Oh, Nexi has one more. He says, right, well, look, yeah, maybe not be poops, okay. I don't know who that's to. Is that to me? Baneling, stop timing him out. God damn it. Stop it. Ah! Don't hide him. Hey. Fucking hell. All right, guys. Thanks for watching the video. I hope you have a good day. I will play the outro. And there you can enjoy that. Come over to Twitch and watch Blue Thunder with me. It will be fun. All right, guys. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who